disposed of bail matter and another matter transfer matter.
Only one. Please give only one memo. Gote memo rakho. Gote memo rakho.
Modification of order, my
Yes. Please mention.
My lord, one TRPL minor
Again?
TRP matter, my lord.
Kono?
Final hearing, my lord.
Fine. Asho the part. Yes.
modification of order.
Yeah.
That okay, yeah.
I am pardon to mention your lordship, RSA number 461 of 2016. Your lordship, the sole appellant died. The substitution already filed. I pray your lordship, only the purpose of substitution kindly may list your lordship on next week. Because of now the respondent creating a disturbance in over the student. Next week any date your lordship.
Fresh second appeal. This is the third time I'm making a mention. It's a fresh second.
A second appeal.
Just second appeal.
Have you pardon? Today's list item 8. May I pray for tomorrow?
Tomorrow there will be no court, so next week.
24. My
This is matter next week. Of supplementary list, Mr. Chand?
supplementary list.
Supplementary list.
24, my lord. You lordship has sent this matter for mediation. My learned friend for the other side. The mediation fixed the date to 25th, my lord. Any date after 25th?
Item 20?
25th date is fixed.
Date item
24, my lord.
Item 24. It is submitted that
First week of August.
it is stated at the bar that the mediation proceeding is fixed to 25th of this month. List this matter therefore, list this matter on 1st August. 1st August.
Interim order to continue.
Interim order to continue.
Obliged.
Make a mention, your lordship. Item 11. On behalf of Anganwadi, I pray for an adjournment.
Item 11. Your 2013 matter.
Yes, your lordship.
No, let it reach LC.
Obliged.
Yes, definitely. Supplementary list item number 1.
May it please your lordship. My lord, in this case, your lordship, 3 cases are there before your lordship, which are matrimonial disputes filed by husband and wife. The first one being the case under domestic violence filed by the wife against the husband and in-laws before the Grammyanalaya JMFC Attavira, Tidwargad. That husband and in-laws that sought for transfer in TRP CRL number 100 by 2019, which is the second one, wherein this honorable court has been pleased to issue notice and stayed further proceeding. Thereafter, your lordship, the husband has filed, I am for the husband. The husband has filed one divorce case against the wife before the Judge Family Court, Bhubaneswar. That the wife has sought for a transfer, that is in TRP C number 273 by 2019, wherein this honorable court has been pleased to issue notice and stayed for the proceeding. That the wife has sought for a transfer from Family Judge, Learned Judge, Family Court, Bhubaneswar to the Court of Bargad. Now, the third one is case under section 498A, filed by the wife against husband and in-laws. In-laws were not charge seated, only husband was charge seated. That is before, pending before Nyadhikara, the Grammyanalaya Attavira, lordship. That I sought for a transfer from TRP CRL number 27 by 2024.
Yes.
That is before your lordship. Now, my prayer is that, your lordship, though I have filed a detailed counter objecting the wife's prayer for transfer from Bhubaneswar to Bargad, but looking at the present developments, your lordship, I pray that my lord may be kind enough to transfer all the cases to Bargad, your lordship, to one place which the wife has sought for transfer.
Yes.
Yes.
All right. In time ko commander hoga na
ସେଇଟା ଦିଟା ହଉଛି ଅତାବିରା ଆଉ ଗୋଟେ
ଦିଟା JMFC Attavira, Grammyanalaya JMFC Attavira.
Pratham tribute 27 of 2024. Present application for transfer has been filed by the husband seeking present application for transfer has been filed of city case number 172 of 2019 pending in the Court of Learned Nyadhikari, Grammyanalaya cum JMFC Attavira to the Court of Learned SDJM Bargad. So it is submitted that 2 other proceedings are pending adjudication between the parties at different courts. Stop. It would be convenient for both parties if the proceeding is transferred to Bargod. Learned counsel appearing for the opposite party wife has no objection. In such view of the matter, it is directed that the proceeding in such and such be transferred. Hala, jaa order of orator. In this case, the same order. Same order, खाली case number टा. TRPC रे, sorry, present application for transfer has been filed by the wife seeking transfer of CP number 428 of 2019 from the Court of Learned Judge Family Court Bhubaneswar to the Court of Learned Judge Family Court Bargod. It is admitted that the petitioner, being a resident of Bargod, it would be convenient on her part to attend the court at Bargod rather than Bhubaneswar, which is more than 350 kilometers away. It is submitted that two other proceedings are pending adjudication between the parties. Stop. Learned counsel appearing for the opposite party husband has no objection to the prayer for transfer. In such view of the matter, it is directed that one. All right. 3 separate orders will be passed. Yes.
Item number 2.
Family matter transfer from family court Puri to family court Khordha.
Yes, have you, Mr. Patel? Mr. Patel, have you appeared in the first 2 cases? Notice पाई ना थी? No, notice जाइए ना? So, do you undertake to appear? Unless you appear, how can I? You file Vakalatama in course of the day. Otherwise, how can it be disposed of today? Certainly. Kitchen, dispose of Kotman. It will be disposed of. We will say that Mr. Ragada, who is appearing for the wife in the connected application, will Kotman. Yes. Yes.
May I appeal? Transfer from family court Puri to family court Khordha.
All right. Issue notice to the opposite party by speed post. Fixing a short returnable date. Requisites be filed by tomorrow. Peremptorily list this matter on
25th July.
25th July. Yes. Adjournment.
Okay.
Item number 3.
May I please? Petition the wife seeking transfer of the case from Learned Judge Family Court Noyagarh to the Learned Civil Judge Seniority Purushottam.
From
Noyagarh to Purushottam.
Noyagarh to Purushottam. All right. Notice. Adjournment.
Item number 4.
The petitioner is the wife, my lord. File this petition for transfer from Jajpur to Bhadrak, my lord.
Jajpur to Bhadrak.
My lord.
Why?
And the petitioner is residing at Keonjhar, but the near Bhadrak. And the father is staying at Kerala. Helpless lady, my lord. 1 year child, my lord.
Notice. Adjournment.
Item number 5. My lord.
Yes.
My lord, so in this case, the petitioner is continuing as working as Anganwadi helper in a Anganwadi center Baharda under Remuna CDP, Remuna block Balasore. My lord, on dated 1/1/2024, CDP Remuna verbally gave order for a discontinuation without any written order. My lord, and there is no provision that and she was attending the center, Anganwadi center regularly, but she was not allowed to do her assignment. CDPO Remuna instructed Anganwadi worker.
What is
not-
this matter? What is this matter? Honorable to
Case is
understand.
that, my lord,
She was
challenging the date of birth at the father of the service, my lord. And disputing the superannuation. He had approached before the competent authority under annexure 2 at page note 13.
You the sub collector.
Yes. And that has been rejected.
actually, she never confessed that no written documents were supplied by the CDPO Remuna before learning sub-collector Baleshwar. Only CDPO Remuna supplied some other document.
Sir, just a moment. You were directed to be disengaged by the CTPO with effect from 1/1/2024. Against that, she filed an application before the sub collector.
Sub-collector claiming that, my lord, the
Okay, how can it come before the sub collector? It should go before the ADM, I believe.
helpers, Anganwadi will help us.
I'm not a helper. Okay.
Helper,
All right. So,
So he submitted she submitted an appeal, my lord.
so that appeal has been rejected.
That has been rejected, saying that she had manipulated the records and
Whatever.
Yes, that
So
is
it has been rejected. So I think the second appeal is there. Is it right?
eight semana pe mutla. It noticed as
Only in worker, not in helper. Helper is not.
है ना 15/3/2024 covers both parts. ମୁଁ ଟିକେ I mean
देखिए हम से गाइडलाइंस टा
no,
देखिए
and accept all.
अंगनवाड़ी गाइडलाइंस का
15/3/2023
to do one thing, Mr. Patnaik, just look at it and passing it over.
Yes.
Let us see whether the new guidelines provide for any second appeal or not. Let the state council go through and passing it over. It will be called out after some time. Yes, pass over. अपन तंग दे दूँ से देखो.
My
Please wait. It has been passed over. The state council will go through the guidelines and find out whether any further appeal is provided under the guidelines. Yes, Mr. Mahathi.
May I please, my lord? Here is the case, my lord. There was an advertisement 2011
Appointment for
based to for appointment of Anganwadi worker in the Dallag Anganwadi center. One person, one lady, Ranjita Mahanti, he by manipulating the records, Ranjita Naik, he got appointment. I approached the ADM, the Anganwadi appeal is allowed. That order was challenged before my lord.
it was allowed.
My appeal is allowed. Annexure 2.
No. So it was challenged before this court.
Yeah, Ranjita Naik, the person was selected.
Yes.
Annexure 4, this one could have gotten stay order. Ultimately, on Annexure 4, after my appearance, and hearing the matter, dismissed it in the appeal. Dismissed the resolution.
Okay.
Thereafter, she preferred a read appeal.
Yes.
Ranjita Naik. During pendency read appeal, she faced termination. On my representation, he faced termination Annexure 5. In the meantime, read has been dismissed. By the individual.
But what remains?
My appointment, I was next selected person, next man. They are not considered my case. I have since 11 I have had.
So let us see the so the appellate courts, appellate authorities order revives.
Yes.
So that is to be what is the direction? So the proof page report having regard
I have paid 20.
having heard both the parties to the dispute and going
Page
through.
20. Page 20, my lord. କିଛି କହିଲେନି ସେ ବିଷୟରେ ମାନେ ଆପଣ କିଛି କହିଲେନି ସେ ଖାଲି କହିଲେ ଯେ ଫର ଆପଣ ଇଲିଗାଲ ସେଠିକି ଛାଡ଼ିଦେଲେ ଲାଷ୍ଟ ପାରାଗ୍ରାଫ ଦଲଗ ରେଡଲାଇନ ରିପୋର୍ଟ ତହସିଲଦାର ନୟାଗଡ଼ one clearly came to that the respondent 5 is not residents of Dallag center. The result, the appellant is accepted. And respondent 5 is set aside.
So there is no direction to appoint you. There's only the direction has been given to the selection committee to consider the matter afresh in light of the findings regarding the service area. So that so it basically it amounts to implementation of this order. So I'll direct the selection committee.
Yes.
So who direction will be given to the sub collector?
Sub collector, my opinion, or two.
Yes.
He is the chairman selection.
The limited grievance of the petitioner is that the directions contained in order dated 11/1/2017 passed by the ADM Noyagad in AW appeal number 14 of 2011 and 15 of 2011 have not been implemented.
After dismissal.
It is submitted that challenging said order was passed on the appeal preferred by the present petitioner, challenging the selection of the
Ranjita Naik.
challenging the selection. It would opposite but number 6 Rashmi Moni Dora Korchen.
No, ସେଇଟା ସେତେବେଳେ ଥିଲା ସେ I am the Rashmi Dora.
Acha, you are Rashmi. Oh, okay.
Ranjita Naik has been selected.
One Ranjita Naik
Madam.
as Anganwadi worker of Jagata Kon
Dolok Gho Center.
Dolok Gho Anganwadi Center. Stop. Said appeal was allowed inter alia with the following directions. Page number 22. In the result, the prayer the prayer of the appellant is allowed. Engagement so and so last age. So, the above order was challenged by said Ranjita Naik before this court in WPC number 11408 of 2017, which came to be dismissed by judgment dated 7/7/2023, passed by a coordinate bench of this court. It is stated that the petitioner carried the matter in an inter-court appeal.
Ranjita Naik petition.
Sorry. Ranjita Naik carried the matter in an inter-court appeal, being WA kind.
W number paragraph 11 1808/2023.
Paragraph 11, na?
Dismissed on 19/3. Copy ଅଛି ପାଖରେ।
My lord,
Sir, High Court will-
Annexure 5.
ସେଟା ଦେଇ ଦଉଛି ତାକୁ।
Annexure 5, my lord, office of the ICDS was at Dodoga, Naigaon.
ହଁ dismiss କରିଦବ।
There is the fourth line, my lord. Read appeal number has been.
ଏଇଟା ମୁଁ
ନାଇଁ ସେ WPC number ଲେଖା ହେଇଛି। ନାଇଁ ରିଟ୍ appeal number ଲେଖା
No,
ହେଇନି।
no, sir, AW office.
ସେଇଥିପାଇଁ ମୁଁ ତ କନଫ୍ୟୁଜ ହେଇଗଲି ସେଇଥିରେ ଆଉ। Mr. Mahathi has withheld that document
ନାଇଁ
for reasons best known to you.
ବହୁତ ବଡଟାକୁ ସେ ଦେଇତେ ମୋଟାଟା ତ
ବଟ ଦେଲେ ଆମେ ଆଜ୍ଞା ଆମର କଣ କୋର୍ଟ ହେଇଯିବ ଆମେ ଧରିପାରିବୁନି ନା କଣ?
ଜେରକ୍ସ ଏତେ ମୋଟା
ମାନେ ଆମେ ଧରିପାରିବୁନି ବଡ ହେଲେ ଆପଣ ଧରିପାରିବେ ଆମେ ଧରିପାରିବୁନି।
ଆପଣ ତ କହିପାରିବେ
ମୁଁ ଦେଖିବା ଏଥିରେ କଣ ଥବ କାଳେ
dismiss
ସେ କାହିଁକି ରଖିଲେ କାହିଁ ଦେଲେ?
ଖାଲି ସେ dismiss ଲାଷ୍ଟ
ଏବେ କଣ ହାଇକୋର୍ଟ ସାଇଡ୍ ସେ ସର୍ଭରଟା ଡାଉନ ଯେ ଆମେ କୌଣସି ଜିନିଷ ଚେକ୍ କରିପାରୁ।
ଡିଫିକଲ୍ଟ ହଉଛି
ଆଚ୍ଛା
କେତେବେଳୁ ଆସୁଛି ରାତିରେ କଣ ଠିକ ନାହିଁ କିଛି
carried the matter in inter-court appeal. Just a moment. Inter-court appeal being writ appeal number 1808 of 2023, which was also dismissed as per judgment passed by the division bench on 27/3/2024. So, pursuant to such order, the appointed candidate Ranjita Naik has in the meantime been terminated as per letter dated 8/9/2023. Stop. It is submitted by Sri Lakshmikanta Mahathi, learned counsel for the petitioner, that in spite of the above developments, no action has been taken thus far by the selection committee to implement the specific directions issued by the ADM. Stop. Considering the limited
only regarding appointment of the petitioner এটা ମୋ prayer ମୋର ଏଟା
he further argues that the petitioner being placed at serial number 2 in the selection process, in the selection, should be given appointment. Considering the submissions as above, the writ application is disposed of, directing the sub-collector Sub-Collector Noyagad, that is opposite party number 2, to take expedient steps to implement the directions issued by the ADM in order dated 11/1/2017 in Anganwadi appeal number 14 of 2011 and 15 of 2011 without any further delay, and in any case not later than 2 months from today.
Item number 7.
7 year also on behalf of Dr. J.K. Lankar also kindly pass over your also.
All right, pass over.
Obliged.
Item number 9.
ଆପଣ ସେଟା ଦେଖିଲେନି ସେ ଯୋଉ ଗାଇଡଲାଇନ
Anganwadi helper ର ମଧ୍ୟ last page ରେ ଅଛି.
Appeal.
It is also first appeal, second appeal.
देखिए देले
Item number 5.
item number 5. Yes, you see the guidelines, fresh guidelines have been issued by the government which provides that second appeal, you have the remedy of second appeal against the order of the sub collector to the collector before the collector. So I will grant you liberty to file appeal.
My lord, actually, she should be allowed to work there till finally adjudication of this case. Already,
You will file appropriate application. You will file appropriate application before the appellate or second appellate authority. He will pass necessary order. In fact, I find that the first appellate authority has passed similar order. She was allowed to continue, but her appeal came to be rejected ultimately.
It has been rejected.
It has been rejected, but you come to this order. I have
Yes,
just.
sir, I have come to that.
I will,
Yes, initially, my lord, there was.
Initially, thila se simti karu. If she is continuing, I will pass that, grant her that relief.
my lord, only one.
Grant her that liberty. Yes.
And my lord, this particular order has been passed on 26/2/2020. Sorry,
21/3/2024.
21/3/2024. Since that, my lord,
काय आपण जाऊनाହାନ୍ତି ମିଷ୍ଟର ମହାନ୍ତି ଆପଣ ସରିଲାଣି କେସ୍ ସରିଲାଣି ତ କେସ୍ ଆହୁରି ଅଛି ତାହେଲେ ଆପଣ ବାହାର ଥାଆନ୍ତୁ ଆସିବେ ଆଉ ଟିକେ ପରେ
My lord, only one.
both Mahanti, Mr. Mahanti are sitting and disturbing the court.
My lord.
so the order dated 21/3/2024. Says then, my lord, it has been dismissed.
So,
No, it is with respect to continuance.
look, so if she is continuing, if she claims to be continuing, if she is continuing, she will make a motion for motion before the second appellate authority to allow her to continue. It is up to,
Yes, ma'am. Yes.
so it is for the second appellate authority to take a decision. इतने कहते close कहते.
Sir, 2A, last page.
My lord, only page
The
number.
last 2 pages are with respect to Anganwadi helper.
Oh, so it will be 2F. Yes.
Page number 16, my lord, in that order it is given, the CDPO was directed to continue the engagement of the appellant, Srimati Phulamani Das, as an interim measure till through verification of document is made to this effect. Accordingly, the appellant is continue as an Anganwadi.
Sir, that was an interim order, but it merges in the final order. In the final, the appeal has been dismissed.
My
So
lord,
that order merges in the final order by the doctrine of merger. So now I will grant you that liberty to, if you are actually continuing, according to you, you say that you are continuing. If you are continuing, you make a motion before the second appellate authority. Similar order will be passed.
CDPO
The
remuneration.
petitioner, the petitioner is, let me dictate the order, sir. The petitioner in the present writ application, he is not challenging, he has not challenged it. Sir, your writ application is wrongly drafted.
Yes, sir.
No, I cannot grant you that. No, I cannot grant you that relief.
Sir, you have page 16, it is there, order to continue. For
ଆପଣ
that,
ପ୍ରେୟାର ଟା ଶୁଣା ଦେଇକି ଆପଣ କଣ୍ଟିନ୍ୟୁ କରିବା ପାଇଁ କାହିଁ ଦିଆଯିବ ଆପଣ ଆପିଲ ଡିସମିସ୍ ହେଲା ପରେ କେମିତି ଆପଣଙ୍କୁ କଣ୍ଟିନ୍ୟୁ କରିବା ପାଇଁ ଦିଆଯିବ you seek withdrawal of this writ application with liberty to file second appeal. I will grant you that liberty. That's all.
my lord, only one prayer.
Yes.
Page 16 of that order, page
On page 16 से चली
here, she was allowed to continue, but
I understand that. Sir, have you any knowledge about the doctrine of merger? An interim order passed, it merges in the final order, and the final order is against you. That your appeal stands dismissed.
for that we are praying for that this must be stayed, that order for continuing. But again,
No. You have wrongly drafted the writ application. The writ application will not be maintainable on that ground. How to stay that order, I don't understand. Without challenging it. You challenge it, that's a different matter.
you vacate the last order, part of the order must be vacated, and her prayer, she is not allowed to do duties by prayer only. Only it is there in the order that she has to continue, but no written order was given to her to continue. Only by verbal order. So you will appreciate that by verbal order, no one can be disengaged, my lord. So my prayer is she should continue till final adjudication of the.
All right. The petitioner has approached this court with the following prayer. Quote करते हैं. The case of the petitioner is that she was working as Anganwadi helper. को Anganwadi center? Ramuna?
Baharda under
कौन सी
CDPO.
जगह है?
Baharda, Anganwadi Center, Baharda. BAHARDA.
Baharda Anganwadi center.
Center under CDPO Remuna, Balasore.
Since there was a motion to disengage her as Anganwadi helper, she preferred appeal before the sub-collector, being SSW, Miss Case number 2 of 2024. Initially, her order of disengagement, initially, as an interim measure, the petitioner was allowed to continue during pendency of the appeal. The appeal, however, came to be dismissed by order dated 21/3/2024, passed by the sub-collector. This court takes note of the fact that the petitioner has not specifically challenged the order of rejection passed by challenge the final order passed in the appeal. Be that as it may, as per the revised guidelines issued by the government in Department of Women and Child Development relating to selection of Anganwadi helper, the remedy of second appeal has been provided against order passed by the first appellate authority, that is sub-collector. Clause 2 bracket small f of the guidelines provides as under. In such view of the matter, the writ application is disposed of, granting liberty to the petitioner to prefer appeal before the district magistrate / ADM, being the second appellate authority, within let us say 2 weeks, within 2 weeks from today. Further, the petitioner claims to be continuing as Anganwadi Anganwadi helper, despite passing of the impugned order, despite rejection of her appeal. Stop. If such is the case, it shall be open to the petitioner to file appropriate application seeking her continuance during pendency of the second appeal before the second appellate authority. 60 दिन तो भी पड़ी थी वो, नहीं की? 60 दिन भी पड़ी थी वो. Further, the petitioner may also seek condonation of delay by filing appropriate application, which shall be considered liberally, having regard to the fact that the petitioner, rightly or wrongly, had directly approached this court in the present writ application. Stop. With these observations, the writ application is disposed of. Yes.
Item number 7.
7 developer. First over it. Oh. It हमें पासवर्ड नहीं थी. अच्छा. The item 5 थी.
The petitioner was initially appointed as junior clerk.
This was heard earlier, Dr. Lenga?
My lord, I had only a short point, your lordship directed our lordship's order, dated your lordship 26/4/24.
Oh, that case.
My lord.
Oh. Admits 4 posts, that is head clerk, UD clerk, accountant, and junior clerk.
They have given.
UD clerk is at the same level as accountant. He further claims that Arjuna Naik was promoted and approved in the post of accountant at 11/6/2019. State Council is requested to ascertain the admissible staff strength of the institution if necessary by producing the relevant order. Yes.
Produce the relevant order on 7/5/24, my lord. Letter number of the government.
As files written, including indicating the admissible staff strength of the institution along with the same be kept on record. Your copy of the instruction was also served
Yes,
upon you.
yes.
What did you find?
Well,
What did you find from that?
they sought the copy on the last occasion.
No, se tu kaun bahar la?
The post is there.
Post is there.
Head clerk, senior clerk, accountant, junior clerk.
Yes.
Petitioner is senior than Arjun Naik. They have given promotion to Arjun. Your lordship kindly see
Let us go sequentially.
my lord. Annex
Yes,
one,
just before you do that,
my lord.
Mr. Patam, we can dispose of.
Yes,
I think the writ application needs to be allowed.
though we have taken some other points, my lord. The lordship importantly questioned me that what is the sanction strength? So to that extent, my lord, I have also clarified that.
So you have clarified there are four posts.
Yes.
And UD clerk is the same as the accountant, isn't it?
But accountant is
Different, my lord.
different post and the sanction.
Post as is, isn't it? Yes, same.
Same kind.
So if one has been given promotion, who is admittedly junior to the petitioner, Arjuna Naik is junior to you.
Wherein we have stated that, my lord, we have complied the order of the honorable court while giving the benefit in respect of.
Doesn't matter. Doesn't matter. Yes, what are the brief facts?
So lordship kindly see Annexure 1, page 7, my lord.
Yes.
Just I am pointing out the facts, my lord. The petitioner was approved as junior clerk, serial number 2. He joined on 11/3/83 and received grantine 88 on completion of 5.
You are Narayana Prasad Naik.
Narayan Prasad Naik.
Yes.
Number 2, my lord.
Where is Arjuna?
Arjuna here is not there.
Acha. Tapare?
Subsequently, he has approved. Your lordship, pursuant to GB resolution annexure 2, page 9, the petitioner promoted to the post of senior clerk.
No, Annexure 2 tat.
Annexure 2, page 9.
Narayana Prasad Naik, junior clerk is in promoted post of senior clerk. Well,
I am discharging the duty till my retirement. Junior clerk, thereafter also head clerk.
so you became a head clerk.
Retired as head clerk. Earlier, I filed writ petition claiming the post of UDC, upper division clerk. My claim was rejected.
Upper division clerk to say senior clerk jahe set upper division
Say
clerk.
senior clerk, UDC. That was rejected.
But why? You are already granted this.
I am a LDC, lower division clerk.
No. Narayana Prasad clerk, junior clerk has been promoted to the post of senior clerk. UDC will kala.
UDC, that is governing body. The approval should be made by the director.
Okay. So approval hela nahi.
Approval hela.
Oh, set up on top.
Again, I came before your lordship and this honorable court directed for consideration of my grievance. And annexure 3, they rejected page 10. I may permitted to read my lord, second para.
Yes.
The petitioner Sri Narayana Prasad Naik said to have been working as UDC in HNS Mahavidyalaya Chandrawal district Kendrapada had filed the approach writ petition before the Honorable High Court for approval of his promotion to the post of UDC. The principal of the petitioner college had earlier submitted revised proposal in Form B, in which he has proposed the name of Sri Narayana Prasad Naik for the post of upper division clerk. It is pertinent to mention here that the appointment of petitioner Sri Naik has been approved by Director Higher Education by the order dated 2/89 with effect from 11/3/83 against the post of LDC, and he is in the receipt of grantine against such post. Only one post of UDC is admissible to the petitioner college on the basis of roll strength. One Sri Bastam Charan Vishwa, UDC of the college has been given promotion to the post of head clerk with effect from 13/10/85 by the concerned governing body. But his promotion to the post of UDC to the post of head clerk have not yet been approved by the government. As only one post of upper division clerk is admissible to the college and the promotion of the senior-most lower division clerk Sri BC Vishwa to the post of UDC and head clerk has not yet been approved by the government, there is no scope to consider the claim of the petitioner for approval of his promotion to the post of UDC. Thereafter, your lordship kindly see annexure 4, page 12, Bastam Naik has been approved against the post of head clerk.
Approved with effect from?
Your lordship kindly see para 2.
With effect from 17/2/84 by the financial.
Head clerk with effect from 13/10/90. Para 2 is UDC with effect from 17/2/89. And para 3, promotion is Vishwa to the post of head clerk is also approved with effect from 13/10/85 and full salary cost with effect from 13/10/90.
All right. Then?
My lord. Thereafter, my lord, your lordship kindly see that Arjun Charan Naik filed a writ petition before this honorable court they have taken stand that on the basis of direction of this Honorable Court, Arjun Naik was approved as a accountant. Direction was to consider his case. I have, your lordship also called for the record. I have also filed affidavit that enclosing the order of this Honorable Court, that is my affidavit dated, my lord, 11/5/22.
Yes.
Annexure 11, page 28.
This is the order.
This is order direction to consider. That is 17/4/2017. Prior to my representation was rejected on the ground that
Yes.
thereafter your lordship kindly see page 35. Arjun Naik was given the post of accountant with effect from 3/12/98. Approval was made.
35 of the writ application.
My lord,
35 of the
that is the affidavit. That affidavit.
of the affidavit.
The running place for us.
35 name. Annexure kete.
That is series 12 series. That annexure continues. My lord, in my affidavit.
Please to accord their
In
concurrence for
internal
approval
page
promotion of one.
Internal page 15, my lord, of my affidavit.
Yes.
Order dated 11/6/19.
Yes.
Approved accountant with effect from 3/12/1998.
Yes.
Approval was made on 11/6/19.
Yes.
And my superannuation, your lordship kindly see page, next page, page 30, annexure 13, my lord. Next annexure. Retired from service as promoted to UDC and head clerk in due time, attaining the age of superannuation on 39/2030. As per government instruction submitted on 7/5/2024, they admitted that vacancy was there and the applicant or petitioner also discharging duties as junior clerk and subsequently also head clerk. And head clerk post is also vacant. Therefore, my humble submission, my lord, I should be given promotion at par with the junior in the against the post of senior clerk and so also head clerk, my lord. With all consequential service benefit as has been extended.
Head clerk gote, senior clerk gote, accountant gote, junior clerk dita.
My lord.
Yes. What is your stand?
Lordship will come to that my affidavit dated 16/4/2024.
Yes.
There was prepared a chart in a tabular form, my lord,
Yes.
indicating the status of all the persons.
Hmm.
And if your lordship will come to para number 3, running page 4, my lord,
Yes.
there we have admitted that, my lord, that it is a fact that in sequence of seniority, Shri Vaishnav Chandra Mishra remains at first position. Shri Narayan Prasad Naik, the petitioner, my lord, remains at second position, and Shri Arjun Chandra Naik remains at third position. In view of the kind orders of the Honorable Court as reflected in the table level, Shri Vaishnav Chandra Mishra got the benefit of promotion to the rank of UDC with effect from 4/9/1985 and head clerk with effect from 1/6/1988, and Shri Arjun Chandra Naik to the post of accountant with effect from 3/12/1998. So, my lord, other than that, my lord, they have not spared anything in adverse to the petition.
So
They have
now
not stated anything.
he should be given the benefits from the date his immediate junior.
In your immediate junior got such benefit for promotion, my lord, and Arjun Chandra Naik, as the chart shows, my lord, that he could got the promotion, got the promotion up to the rank of the
Head clerk.
UDC.
No, UDC तो accountant वाला.
No, सेती की से.
हाँ, आपने लिखिन पर है.
No, thereafter, my lord,
He was approved for
no,
getting
he was
promotion to
never
post of
considered for
accountant.
the post of the head clerk, my lord.
Head clerk छोड़ दूँ.
To the post of the UDC, my lord, yes.
But in the meantime, I think your client has also retired as head clerk.
2007.
So it has to be antedated.
My lord.
Antedated to the last to the date on which Arjun Naik was granted promotion. Yeah, ना कौन होगा?
Arjun Naik,
Yeah, तो.
my lord.
This is your claim.
My lord.
2000.
So it has to be from 3/12/2019. 1998 ठीक है
Senior clerk, my lord.
हाँ सीनियर क्लर्क है
Senior clerk Arjun Naik got my lord with effect from 3/12/98. You will also.
सर कुछ 3/12/98 कुछ
98.
so if you your when did you get your senior clerk just a moment आपका appointment
Your lordship kindly say.
your appointment
My appointment is senior clerk.
no your initial appointment
Initial appointment is junior clerk in 11/3/83.
your 11/3/83 when was it approved
Approved on 2/12/89 with effect from
date of appointment
8/3/88 after 5 years.
8388
1/3 granted.
so this is the
With
this is the date from which it has to be calculated
My lord.
with effect from 11/3/1988.
11/3/88 approval है सेदिन तो
11/3/88 approval.
so senior clerk अपन केबे हले
Senior clerk only 85.
नहीं सेटा केबे हले कोन
13/10/85.
13/10
85.
85 so when was that approved
My lord.
that was never approved
That was not approved.
so how could you become then senior clerk and head clerk केम थेले
Governing body is.
governing body
Governing body is the competent authority to promote and submit proposal.
so head clerk केतले है केबे हले
My lord.
when did you become a head clerk
Head clerk, my lord, subsequently.
not very relevant but just to know the dates
At the verge of, before the just verge of, I am not the date, my lord.
he may have been promoted by the management way back on 13/10/1985 to the post of senior clerk UDC whatever
Thank you.
Arjuna Naik but so far as the petitioner is concerned despite the management promoting him to UDC way back in 1985 it was never approved
Annexure 3. Pay note 10.
ये rejection कोले पर
हाँ.
कोले on the ground of absence
One
of post नहीं
And with a specific that the petition for approval for promotion to the post of UTC at present, the claim is rejected at present. Because not for non-ability to post, but thereafter.
Because of
They have
approval of senior person. Senior person.
चीजू नारायण नायक
No, my lord, that is
Biswa.
Biswa.
विश्वा
Subsequently, Biswa was approved with the retrospective effect.
so that has to be seen
And Biswa's promotion to the next higher rank, my lord, that is head clerk. Because of one post, my lord, he could not, as per Annexure 3, Biswa's approval in the post of head clerk, my lord, that was with effect from 12/10/1990 at that Annexure 4.
but
So the
After
petitioner-
retirement of Biswa, I got the head clerk post. Much after
the
retirement. of the-
petitioners claim, my lord, that by the time 12/10/1990, after the approval of the promotion to the post of the head clerk, the post of UTC line package. But as
नहीं
against
सी
that
केबे गले
Sir?
सी केबे गले वैष्णव विश्वास
12/10/1990
12/10/1990 सी दोटे वैकेंट हला
ସେଇଦିନଠୁ
ସେଇ କ୍ୟାଟାଗୋରୀ ଦିଟା ଭ୍ୟାକେଣ୍ଟ ହେଲା ଗୋଟେ ଆକାଉଣ୍ଟାଣ୍ଟ ହେଲା ଗୋଟେ ୟୁଡିସି ହେଲା ଆପଣ ଦେଖୁନାହାନ୍ତି କମ୍ ଟୁ ୟୋର ଓନ୍ ଆଫିଡେଭିଟ୍
ଚୌରାଶୀ ତାଙ୍କର approve ହେଲା.
ୟୁ କମ୍ ଟୁ ୟୋର ଓନ୍ ଆଫିଡେଭିଟ୍
BC Biswal LDC in the post of UDC is approved with department 7/2/84.
ହେଡ୍ କ୍ଲର୍କ ପୋଷ୍ଟ କେବେ ଆପ୍ରୁଭ୍ ହେଲା?
Head coach post ହେଲା 85 ରେ approval ହେଲା.
ୟୁଡିସି ପୋଷ୍ଟ ଆପଣଙ୍କର ଖାଲି ହେଲା ସେଦିନଠୁ
13/10/85.
କନସିକ୍ୱେନ୍ସିଆଲ ଟାରେ
13/10/85 ମୁଁ ବି 13/10/85 ରୁ promotion ପାଇଛି.
No, 13/10/85 ରୁ ଖାଲି ହେଲା ମ୍ୟାନେଜମେଣ୍ଟ ସିନା କଲା it was approved when he became when his promotion to the post of head clerk was approved then only there was a vacancy created
vacancy but this case has never been approved.
Approved 13/10/85.
This case has never been approved.
so it has to be retrospectively approved from the date the vacancy arose in the senior clerk?
In-
No, no,
in
you,
case of-
junior clerk has been approved.
In case of Vishwal and both Vishwal and Naik retrospectively approved.
So his case also should be considered for retrospective approval.
But with respect to that other person, my lord, the junior got the promotion. That is not approved from.
That is approved from 1998.
1998.
Maybe. How is he concerned? How is he to be blamed for that? You see, his case was rejected on the ground that there is no vacancy.
Yes, ma'am.
But once this Biswala becomes head clerk, automatic vacancy arises in UDC.
Yes.
Arjuna Naik was never promoted as UDC, but in a equivalent post, which is accountant.
Yes.
So that post is still lying vacant.
Yes, ma'am.
So the day Biswala became promoted and this petitioner being senior to Arjuna Naik has to be considered from that date,
We have to consider,
retrospectively.
because unless and until, because it is a promotion, unless and until a person is
Found fit.
considered and found suitable by the.
That is there, of course.
But right for consideration, my lord, to that extent, your lordship.
No, from that date it arises.
Yes, yes.
So even if accepting Annex 3, it no longer stands good in view of promotion of or the approval of the promotion of Biswala.
Annexure 4. On Annexure 4, my lord, now approval has been granted, my lord.
Hmm.
So in view of that, my lord, Annexure 3, at present, my lord, that is why my.
No, you are wrong. The promotion of Sri B.C. Biswala in the post of head clerk is hereby approved with effect from 13/10/85 and granting it full salary cost with effect from 13/10/90. So granting it date is irrelevant.
My lord.
नहीं की 13/10/90
Yes,
12 ବୋଲି ଆପଣ କହିଥିଲେ 13/10. So 13/10/90 becomes the relevant date on which the approved post of UDC becomes false vacant. He should have been considered.
So far as granted date, he has approved with the program 85. Granted date was even after 5 years. Well, approved granted date was even after 5 years.
So-
Approved 85. Suppose I am
So
approved
your case has to be retrospectively, according to you,
Minor.
should be retrospectively approved from which date?
from 10/10/85. And
So for approval is concerned, my lord, from that date.
from
85.
Approval has to be from that date.
Yes.
Granted date से also approved है विशाल का.
my-
And that was shown as the sole impediment by disposing the representation at Annexure 3.
Annex 3, when was it passed?
On 12/3/2004.
12/3/2004.
But
This is subsequent development.
8/8/2008.
This is subsequent development. This has not been taken into consideration.
So that should have been taken into consideration.
So what order can be passed?
Except operated.
No, but since he has retired in the meantime,
Yes.
it has to be retrospectively approved because no adverse, nothing as well adverse has been shown.
All the
against
three
him.
persons, my lord, I think, my lord, everybody got retired, my lord, in the meantime. This
Acha,
Annexure
I am
3
dictating the order.
my lord.
Please correct me if I am wrong.
My lord.
The factual aspects. The petitioner has approached this court seeking the following relief. The brief facts of the case are that the petitioner was appointed as a junior clerk in कौन सी जगह की कॉलेज चांदोड़ कॉलेज
HNS महाविद्यालय चांदोड़
एचएनएस महाविद्यालय
चांदोड़
चांदोड़ কিন্তু এটি অ্যাপ্রুভাল অর্ডারে চাंदোড় কলেজ কে লেখা আছে
তা subsequently that was Hudananda Memorial
আচ্ছা
Institute.
एचएनएस महाविद्यालय चांदोड़ on 11/3/1983
83.
his services were approved on 8/3/1990 8/3/1988 where is that order?
That is Annexure 1, page 7. For receiving-
8/3/1988 as per order dated 2/12/1989
under direct payment scheme.
under the direct payment scheme. Stop. The management promoted him to the post of senior clerk bracket UDC by order dated 13/10/1985. 13. The petitioner's grievance is that despite availability of posts from that date, his promotion as senior clerk was never approved. So, ultimately, no, he was never approved. Further, person junior to him, namely Arjun Charana Naik, was promoted as accountant, comma, which is a post at par with senior clerk bracket UDC, with effect from
3/12/1998.
3/12/1998. Stop. His such promotion was also approved with effect from the said date. The petitioner made several representations for consideration of his case. No, stop. Since no action was taken, he approached this court in WPC number 565 of 2003, which was disposed of on 26/8/2023, 2003, directing the director to consider the case of the petitioner for approval.
Direct the government.
The government government actually to consider the case of the petitioner for approval of his promotion to the post of UDC. Stop. By order dated 12/3/2004, the commissioner cum secretary rejected the grievance of the petitioner on the ground that only one post of UDC is admissible to the college, and the promotion of the senior most LDC, Sri B.C. Biswal, to the post of UDC and head clerk had not yet been approved by the government. Stop. Dr. J.K. Lenka, learned counsel for the petitioner, submits that the reason cited for rejection of the petitioner's grievance no longer holds good in view of order dated 8/8/2008 passed by the government, whereby the promotion of DC Biswal to the post of head clerk was approved with effect from 13/10/1985. Therefore, according to Dr. Lenka, one post of UTC fell vacant as on the said date. Being directed by this court, Learned State Council has filed a written instructions indicating the admissible staff strength of the college, which is as follows: head clerk -1, senior clerk -1, accountant -1, junior clerk 2, junior clerk block grant 1. Stop. In the counter, in the affidavit filed by the state on 16/4/2024, it has been admitted as follows. Paragraph 3 add करते है ना. Thus, in view of the admitted factual position noted above, to the effect that the petitioner is senior to Arjun Charana Naik, there is no reason as to why his promotion by the management to the post of senior clerk bracket UDC shall not be approved, at least from the date said post was available. That is 13/10/1985. Isn't it? Yes, Dr. Lanka?
My lord.
Yes. It is further noted that it is further relevant to note that the post of accountant is at par with the post of senior clerk bracketed UDC, carrying the same scale of pay, that is rupees 1200-2040. The pay equivalent to the post.
Yes, ma'am.
As per the affidavit filed by the state on 16/4/2024. Since this court finds from the materials on record that one post of senior clerk bracketed UDC was available on 13/10/1985 upon approval of promotion as head clerk of BC Biswara. There is no and further that his immediate junior Arjuna Charana Naik was granted the benefit of the higher post, was approved again,
Approved on 3/12/19.
Arjuna Charana Naik's promotion as accountant was approved
With effect from 3/12/1990.
with effect from 3/12/1998. There is no reason why the petitioner should be discriminated. Stop. Nothing has been placed on record to show that the petitioner is not otherwise eligible for being promoted to the next higher post. Stop. It is also, nothing has been considered. It is unfortunate that the matter remained pending with the government, with the appropriate authorities for so long, resulting in retirement of the petitioner on superannuation.
With effect from 30th September 2013.
On कहते
30/9/13.
without his services in the promotional post being approved. Stop. On a conspectus of the analysis of facts and the discussion made thereon, this court finds the petitioner to have made out a good case for interference. Stop. The writ application is therefore allowed. We need not quash that in the impute order because that is the cab direction of a government.
Government.
The government, the secretary to government in the higher education department is directed to retrospectively approve the promotion of the petitioner to the post of UDC senior clerk bracketed UDC with effect from 13/10/1985 and to the post of head clerk C को दोनों Arjuna को दोनों है नहीं.
The prayer is also, my lord, the prayer is
Yes, I think so.
confined to
Consideration for head clerk, my lordship.
And to consider
After retirement of a Biswala, I got the post.
consider the consider approval of the petitioner's post, petitioner's promotion to the post of head clerk from the date his immediate senior BC Biswala retired on superannuation. Man, जो दोनों से vacant है.
One thing may I add, your lordship, permission, kind permission. They may not give a salary from 85. Therefore, I am praying from the date Arjun Charan Naik got direct payment granted, that is 3/12/98. That date to mat diya at least. They
It
may
is very clear that approval of promotion from 13/10/1985 shall be on notional basis, but actual financial benefits of the promotional post shall be granted from the date Arjuna Charana Naik, bracketed his immediate junior, was received financial benefits, that is data
3/12/98.
Eh?
3/12/1998.
3/12/1998. Yes, that's all. The whole exercise should be completed within a period of 2 months from the date of submission of certified copy by the petitioner. That's all. Any other factual error?
No.
May I submit, my lord, that since it is a case of promotion and approval of the promotioner, so this case is to be considered by the
Considered by the governing body. Governing body is the authority, governing body.
Governing body to correspondent.
My lord, there will, yes.
Governing body to
Only
Not
formal
to the post
approval.
of this head clerk, my lord. Not to the
Considered.
post of head clerk.
consider
My lord, director consider.
consider.
Yes.
It is already managing committee to governing
Yes, ma'am. The same affidavit, para number 3 also we have indicated.
That is why I have quoted it.
Yes.
Even though 85, I am not claiming 85 to 98, my lord. Even 11 years, because they may go for appeal as per, that is why I am claiming.
Yes, item 8.
Item number 9.
It adjourns.
Item number 9.
May I please, my lord.
Hard copy of the counter will kindly.
ଆଗରୁ ଫାଇଲ କରିଦେଇଥିଲେ
E-filed.
ଇ ଫାଇଲ ହେଇଥିଲା ଆଚ୍ଛା
I have received copy. I have also filed rejoinder.
ରିଜଲ୍ଟ ହେଇଯାଇଛି ତ
ହଁ, ମୁଁ
ରିଡିଂସ୍ କମ୍ପ୍ଲିଟ୍
ଆଜ୍ଞା.
ଅଲ୍ ରାଇଟ୍ କ'ଣ ହ୍ୱାଟ୍ ଇଜ୍ ଦିସ୍ ମ୍ୟାଟର
Here is the case, my lord. The petitioner with the continuous headmaster in charge of the school. They challenge the order passed by opposite part number 3 under annex.
What is this common judgment which I have rendered?
That has two particular persons. There is no link to this case. Particular 2 persons, they are fighting for the headmaster post. Not the matter close the chapter.
All right.
Here I have challenged annexure 18, page 39. On the ground that under the Orissa Education Act and the rules framed thereunder, there is no such provision that the headmaster, the staff of the school shall be attend the nearby office of the BO every day to sign the attendance register, and they have discharged duty to the school. And the attendance register shall be kept with the office of the BO. The managing committee was approved in 2009, 2010, 2013, the management committee term was over. They have a proposal submitted. As per the statute,
No, let us see your prayer, Mr. Mahathi.
annexure 18 you have a question.
No, I have a prayer to propose. So why the order dated 28/3/2018 under annexure 18 shall not be quashed? After hearing the wala. Annexure 18. Annexure 18 is the order.
That order has been passed by the note 3.
Indicate a place କରନ୍ତୁ ଜାଣିବା କେମିତି?
Approach of the official recording file and report of the DO Mayurbhanj. Bariputta file letter note so dated 6/5/16 of the Director Secretary Odisha. Besides the verbal report of the collector Mayurbhanj, one thing apparent that neither the present IC headmaster of Chitral High School is alert and responsible to her duty and responsible as expected of her, nor she is running the school with maintenance of impartiality with all staff members. On the other hand, there has been rheumatism and conflict created by the IC headmaster who is supporting one group and defying another group amongst staff members.
So come to the next page. So these are the responsibilities that have been
That next page, my lord. Last paragraph.
Page 39, last paragraph.
Okay.
39, last paragraph. Accordingly, since the respective BEO in the entrusted have been entrusted with the responsibility to inspect and supervise all high schools, irrespective of status of the headmaster administrative point of view, as per job chart prescribed by the government GO note so upon reorganization of school and mass education department, the BO Moroda under whose jurisdiction the Chitrada government block and high school is located is hereby entrusted with the following responsibility. to discharge by him with regard to Chitroda Girls High School as a stop to arrangement subject to result of the WC so and so. All correspondence by the headmasters.
So what is this? These are six
Conditions.
conditions.
So I will challenge that because under the statute,
Who are you?
I am the administrator.
You are the administrator.
I am director to my staff attendance register shall be kept to the office of the BO, and every day we have to go there, sign the attendance, thereafter attend the school. That is nowhere prescribed in statute matter. Statute said if the managing committee has been rule 772, if the managing committee has been expired term, either they will continue or the prescribed authority appoint a person to be the management of the school. That is statute matter. Rule 72 of the 16 rule. Management rule says the prescribed authority is 91 management rule. That's the prescribed authority is director. Rule 26. So director either they will be allowed to continue with the previous managing committee or appoint a person to be to look after the school. But here is the case, there is no such provision that with the entire staff will go to the another office, attend, sign the attendance there, and they have to attend the school every day. Previously,
Come to paragraph 2.
Yes, madam. As and when report on
Paragraph 2 टा पढ़ना थी. Paragraph 2 टा पढ़ोगे टी. Since the girls' high school is located within a walkable distance from the office of the BO Moro.
Also part 2 of the order, madam, sorry. Since the girls' high school is located within a walkable distance from the office of the BO Moroda, that too continues to main road, corporation girls' high school, all the teaching staff nonsense shall be signed the attendance register every day in the office of BO Moroda before a perform duty. That is not a challenge, madam. That is never nowhere in the statute prescribed.
Why? Yes. Why this onerous
an arrangement for the situations that prevail.
But whether the situation prevails now, that was in 2018.
Yes.
We are in 2024 now. 6 years of
Their direction by this one earlier other cases to recommend in 3 months. Till they cannot take any step reconstruction.
All right. No. Let that managing committee be reconstituted. That's all right. But till reconstitution, let there be a special officer.
Yes.
Let the government take up that matter. You are appealing for whom, Mr. Mathi?
I am the intervener from the staff of the college. That was there the till.
Are you supporting him or opposing him?
In fact, I am neither supporting the petition nor the other thing. Both are creating disturbance in the school. They are fighting with each other.
I will directly.
There is a observation that till disposal 96/1/2012. That's repetition is disposed by a common order on 10/4/2024. Only this repetition has been kept aside because of the request of my learned friend. It is separate because everything has been set right by the disposal of the common repetition in 10/4/2024. Only things remain the context. Rasta separate. There is no distance.
No, maybe. There may not be any distance. But the question is, firstly, why should the attendance registers of one institution be kept in another institution? Why should it?
Just I am submitting. When the petitioner will remain in charge, he will be deprived. He will be divided the others not to sign.
No, how can she do that?
This is the inquiry report of submitted. I am not saying. Submitted by authority. I am not submitted there. Let there be a peaceful continuation of the school by intervention of this court. Otherwise, it will still continue, still persist till now.
If the managing committee is reconsidered or any special be appointed by director, everything will go over by lot. And another person approach the locality for the same issue. Locality observed that this order is illegal.
That
was challenged by my friend.
That relates to other thing because 3 months they have not attended the schools. And the BO has inquiry and report that they should not provide the letter.
What is your counter? What is the stand taken by you in account?
Counter justifying the action for the reason that prevailed. The situations that prevailed, paragraph 9.
No, but that was in 2018.
That long back.
So what is the present status now? I want to
status is that arrangement is continuing.
Why should it continue?
Your lordship would direct because in the rejoinder, his main emphasis is on reconstitution of the managing committee.
Rejoinder is not on record. Rejoinder is not on record. No, that's all right. But why should the authorities have to act as per the statute? That's all.
Yes, let them act, but till the normalcy arises, the prevails in the school, let the present arrangement continue till let the management be reconstituted.
Because of the impasse continue because of disturbance between the petitioner and other counterpart.
No special officer has been appointed.
No, in the counter, we have not said any.
Counter so same thing, not because of the situation and they have done the counter, they have earlier taken the ex-inspectors who approved the managing committee. Paragraph 13. We are for the school and they are already in the ex-inspector school by the DO, by the present DO. That ex-inspector school has approved and that was created the problem. Not to get any step for recall managing committee so that the peaceful atmosphere will come in the school.
No, we will do one thing.
Nahi, your opinion.
I'll just simply ask you to bring out the present status of the EA. By order dated 28/3/2018, certain directions were issued by the DEO Mayurbhanj. The writ application has been filed challenging said order on the ground that the conditions imposed are onerous. Then State Council submits that the order was passed looking at the troubled situation then existing in the institution. This court would like to know what steps have been taken for reconstitution of the managing committee, the term of which is said to have already expired. Further, what is the present status of the institution insofar as the disturbances are concerned? Learned State Council shall apprise the court accordingly. List this matter would be week time there. 1st August, Mr. Das.
Sir.
Please make a note.
Sir.
Then I'll pass that order.
Hon'Ble.
Okay.
My lord, in the
Yes, what is this matter?
Your Lordship, I have class, Your Lordship's order 29/4.
No, the RDC with the
Yes, my Lordship.
RDC has conducted the inquiry.
Yes.
Where is that report?
may be permitted to stop. At Khannagar Mojipoda,
No, I know. What is the finding?
well, Lordship may come to considering the report, my lord, that is 4th page, my lord.
Page 4.
Page 4, but the paging is not here.
Okay.
Page Karnataka.
Page Karnataka.
The last but 2 pages.
Considering the reports of the ADM.
Yes, sir. Kendrapada, the Tahsildar Derabis, the statement of Srimati Dalai, the petitioner, and Srimati Pradhan, the written statement of the CDP or Derabis, and after going through the test map and other documents and the status of enrollment of the children in various AWCs, it is proved that Mojipada is not a part of the Khannagar mini honorability. Mojipada could never.
Your Lordship may peruse your, I may permitted to. Your Lordship's order, kind of on 3 order ticket. I may permitted to read Your Lordship's order on 3. As directed, Mr. Patnaik Laurent, additional government advocate, has produced the original file containing the report of the committee regarding determination of the service area of different Anganwadi and mini Anganwadi centers of Kendrapada district. He points out that the service area of Khannagar mini Anganwadi center is mentioned as Khannagar and Mojipada.
Khannagar, Mojipada.
Yes, Khannagar, Mojipada. This court also has perused the said report. The file also contains the original advertisement dated 16/12/2009, where the service area is mentioned as Khannagar, Mojipada with initial of someone. The name of the mini Anganwadi center is mentioned as Khannagar and the words Majipada appears to have been scored through. As compared to these documents, the affidavit filed by the collector Kendrapada on 16/2/23 is to that effect that Majipada does not come under service area of Khannagar mini Anganwadi center. This court further takes note the impugned order at Annex 1 passed the ADM wherein the head as follows. From the joint inquiry report of the DSW Kendrapada and the CDPO Derabis, it is clear that the original name of the mini Anganwadi center is Khannagar. It has been manipulated and tempered in the instance of CDPO Derabis. This court has already mentioned the fact of manipulation in his order dated such 24/10/2013. Therefore, the DSW Kendrapada is directed to cause an inquiry into such manipulation and take appropriate action against the person and fault. As per the joint inquiry report, the respondent number 2 belongs to Majipada hamlet, which is coming within the territorial jurisdiction of the revenue village of Hon'Ble. The resident certificate issued by the Tahsildar Derabis Vahid case number such and such corroborate the same thing. Therefore, it is clear that the respondent number Sanjukta Dalai being suffered hamlet Majipada under Hon'Ble revenue village. Further, the area of operation of the mini Anganwadi center is only village Khannagar. As such, the respondent number 2 is not coming within the jurisdiction of area of operation of mini AWC Khannagar. Therefore, the candidature of the respondent number 2 was required to be rejected at the time of scrutiny. But as stated above, due to manipulation, tampering in the advertisement, the respondent number 2 Sanjukta Dalai got engagement as Anganwadi in Khannagar mini Anganwadi center. My lord, your lordship has verified the original document as well as original advisory. Your lordship clearly mentioned here that the proposal was both for area of operation was both for Khannagar, Majipada, and the advertisement was for Khannagar and Majipada. Apart from that, your lordship, kindly go through my writ petition.
Mr. Pratap,
My lord.
this court will not enter into a factual controversy. For that, it constituted a committee headed by the committee or inquiry to directed the inquiry to be conducted by a very senior officer, the RDC himself.
Yes, Lord.
He conducts an inquiry and he gives a finding. Unless you challenge this finding specifically, this finding has to be accepted by the court. How unless it is shown that on the face of it is wrong. Otherwise, how can the court enter into a factual finding? Tell me, a writ court.
Your lordship may kindly have a glance to the writ petition. The page of the writ petition is 38.
For what purpose are you?
In the counter, on the counter they filed and they are admitting.
So can this court substitute its own opinion for that of the RBC? Purely factual. Whatever, they may have filed a counter. They may have filed it wrongly on wrong.
All these things were taken into consideration and subsequently
You
modified.
go through the report. If you want to, you can challenge this report if you want. Otherwise, this court will abide by the report. But this is after all a certiorari proceeding. How deep can the court enter? चिंता करो तो decide.
ଗୋଟେ data ଆସୁ ମୁଁ ଟିକେ report ଟା ଏବେ just ମୋତେ supply କଲେ ମୁଁ ଟିକେ
ଆଜି ଦେଲେ report ଟା?
just
ତାହେଲେ କେମିତି ହବ? See, let him go through. He has to challenge this report.
Yes.
Maybe not may not be in this writ application because I'll dispose of in terms of this writ application, leaving it open to him to challenge if you want to. That liberty I will grant you.
just I am receiving the
All right. Shini.
Yes.
Similar matter has been posted to 7/8. Which matter? Yesterday, item 13. Rate number 10852 of 2013.
Have you served copy on the state council?
Sir,
They want to impede the Chancellor of Utkal University of Culture and Finance Department. Will allow it? But you serve a copy.
Yes, sir.
IA 8802 of 2024. This is an application for amendment of the writ application to impede the Chancellor Utkal University of Culture, and the Government and Finance Department, represented through its Principal Secretary, as opposite parties in the writ application. Government State Council and the Council for the University,
University Culture.
Utkal University of Culture,
OP number 3 and 4.
have no serious objection to the amendment being allowed. है ना? The prefer is amendment is allowed. The persons at schedule to the IA being pleaded as opposite party numbers 5 and 6 respectively. Consolidated cause title be filed within 3 working days. Notice has to go to them.
Minor
There are
in this
two
case,
read
WPC 14696/2013. That is a separate matter, madam. That may be.
Sir, dealing kariba. So you also file requisites? Requisites for issue of notice on the newly added opposite parties be filed. Be also filed within 3 working days. Notice be issued fixing a short returnable date. List this matter.
7th August.
On 11th August.
7th August.
7th August. आरा matter ta कहला आता delisted हो.
हाँ, my lord, 14696/2013. That may be separate issue.
WPC 14696 of 2013 to this
Different.
matter be delisted.
Different.
Yes.
12.
Let's see, on the last occasion I've been dealing with a senior to take instruction in this matter. Is it kindly recollect that matter, my lords, this school is taken over by run by the Manadi Coalfields, and prayer is to be taken over by the state government.
Yes. Current status.
Okay. Instruction though has not been received, but from out of the other records available, I gathered that the state government is not willing to take over.
How?
Because of the situations prevailing in the school, because there is less strength of students and all that.
But then you have to seek modification or review of that order from the Supreme Court.
And
as long as the Supreme Court order stares at your face, you cannot do anything about it. You can't say that we will not comply with that order. That is unacceptable.
Your Lordship may directly let them consider, because of the position of the school that has been applied to me by my Lord friend for the MCL. That also depicts such a position.
Whatever may be, you may seek modification of the order, you may seek recall of that order, review of that order, whatever. But as long as that order exists, you cannot say that we will not comply with that order. That isn't.
Yeah, that would amount.
State government is also silent after getting this letter, page 21. That is also proposal from the MCL, page 21, annexure 5, your lordship, on the last occasion.
I'll dispose of directing them to take a decision within a short time.
Yes, taking into view this letter, annexure 5, my lords. Annexure 5, page 21. Even my lord and friend has fairly stated in paragraph 5 also, of its paragraph 3 of the counter.
By the MCL.
Yes, page 21, annexure 5 of the writ petition.
Yes. No, already that order was passed by this coordinate bench, and so order annexure 9 has been passed.
No, annexure 9 was representation disposal. So annexure 5, page 21, my lord. Page 21, annexure 5.
No, but the page annexure 5 is prior to annexure 9.
Yes, but in
what you have challenged is annexure 9 before this.
Challenging annexure 9, but this annexure 9, my lord, this letter has not been referred to.
Yeah, that's all right.
And in paragraph 3 of the counter affidavit filed by learned friend MCL, they have also said that they have also page 3, paragraph 3, my lords. This opposite party white letter dated 33/2000, my lords, requested the Director Elementary Education Orissa for takeover of primary schools with effect from.
He has referred to
Yes.
the judgment of the Supreme Court.
Aye.
Yes.
Let's kindly dispose.
So he's saying where the Supreme Court has not given any direct direction, positive direction,
No, there is a
That is
reflection.
in respect of other schools.
No, page 14, let's see, may kindly see. They say that page 14, annexure 1 of the repetition.
This is relating to your school.
No, it's related to another school. Also similarly situated, MCL, taken over by. It's a, my lord, the last line. We also note from the judgment of the High Court that at present, all the primary schools in the state of Odisha have been taken over by the state government. Though it relates to, my lords, Orient Colliery, which was before Honorable Apex Court after challenging the order. But there is a submission made, my lord, that all the primary schools have been taken over by state. In that view, this letter 33/2000 letter was issued by MCL seeking permission. Lordship disposed of directing to let them, because 10 years in the meantime past, state has not yet filed any counter affidavit, and 3 out of 5 has retired in the meantime.
You refer to another judgment of the Supreme Court.
But that is how far it is relevant, my lords, that your lordship.
This order was passed way back in 2014. 10 years have passed.
Yes.
So that is why the current status is necessary. You have to obtain that.
Your lordship would do it.
Only if you finally say that even in 2024, the state government is not willing to, take over the school, then
That would be only on the present prevailing situations in the school, maybe.
Yes. Whatever. Learned State Council requests for some more time to comply with the previous order. Place this matter on 25th July. The previous order will be complied with positively.
Only I pay your lordship kindly grant for the last chance, so otherwise 10 years, lordship kindly.
Yes, 2023, sorry.
Lordship.
2023 will complete. Yes.
I cannot have.
In my lord, after the single taken time to file counter.
You are filing the counter.
Yes, the counter has been filed.
Counter file is देख लो.
E-filed. The hard copy is there with me.
When it State Council files hard copy of the counter, e-filed earlier. Copy of the counter is served on. Serve it. Nahi.
Where workman I will be serving.
Copy of the counter be served upon counsel for the petitioner. Place this matter August. On 8th August. Rejoinder if any be filed in the meantime.
Item number 14.
The petitioner in this writ application challenges the order dated 27/6/2017 passed in Anganwadi appeal, wherein my claim to hold that opposite party number 4 is incompetent to be selected has been rejected.
Yes.
My lord, the fact is like this, my lord. There was a notification on 31/10/2011 for inviting applications for the post of Anganwadi workers. Original certificates were called for and verified. The present petitioner and the opposite party number 4, along with 2 others, were the candidates to the said post. My lord, as my objection was not considered, I came up before your.
What was your objection?
That she is incompetent to be selected.
Why incompetent?
That I disputed the marital status and all other facts. Does not belong to the center area. Marriage was also disputed and other factors were there. I came up before your lordship in writ application. The said writ application was disposed. I have quoted the order at page 4 of the writ application.
Yes.
Thereafter, I preferred an appeal before the appellate authority. The appellate authority passed this order. Page 9 starts. It starts from page 9. The relevant portion is at page 13. Your Lordship will see he refers to the pleadings of the parties. At page 14, your Lordship will see the advocate for the petitioner has objected to the certificate issued by the Devotar manager Harishankar Temple, stating that Harishankar Temple authority is not an authentic one and the government has not authorized Devotar Patnagar for performing marriage at Harishankar Temple. The objection of the learned advocate does not appear to be relevant as none has the locus standi to question a religious activity and faith of any national. No one can oppose to the marriage function at religious place of the community, and the Devotar manager, being in charge of the management of the religious institution, is supposed to have information of the activities that took place there. The objection / complaint of the petitioner Sunamani Bag, who is petitioner before your Lordship, against the residential status of Tikeshwari Barik, opposite party number 4 before your Lordship, has not been found genuine after inquiry. My Lord, where was the inquiry? There was. Question is, my Lord, when an appeal is there, he does not rely on any inquiry. The report of the Tahsildar Patnagar on the matter dated 16/11/2015 is sufficient to reject the objection raised by the petitioner as per the clarification issued by the government on the matter referred to the foregoing paragraph. The findings of the Tahsildar Patnagar has been found correct in joint inquiry by Assistant Collector Patnagar and SSO Patnagar. It is evident that Tikeshwari Barik married to Santosh Suna of village such and such on Mete. She has been issued residence certificate and caste certificate by the Tahsildar Patnagar on 15/11/2011, showing that she is wife of such and such. She has applied for the post of Anganwadi of on such and the strength of residence and caste certificate issued by the Tahsildar. Here, one argument may be advanced by the opposite party that this residential certificate and caste certificate has not been challenged in appropriate court. The law is, my Lord, that if a residence certificate has been issued or a caste certificate and issued, that is under the miscellaneous certificate rules. There is a provision of objection, review, as well as an appeal. It is a fact that my client has not questioned that. Then once he doesn't question that, that is operates as res judicata for me. That is what which I cannot get over, because that is the counter that my residence certificate or caste certificate has not been questioned by the present petitioner before your Lord. This stares at me. This is the fact. Because unless those are challenged, that it is deemed to be correct, it has to be challenged in appropriate court. Sir, more duty, more.
The petitioner challenges.
I should not, if not been,
No, this court always appreciates your fairness, Mr. Bose. Whatever.
I told him that you do that. He said, no, you come.
No, marriage is also been registered, my lord. Certificate I have annexed in my counter.
No, in your counter, not before the ADM.
My lord.
Not before the ADM.
ADM the marriage register.
Not my lord. Not before the ADM.
This court will not enter into that aspect.
My lord.
It's a purely question of fact.
My lord,
The ADM on his own inquiry, the sub-collector, I believe. It is the sub-collector, not the ADM.
Yes,
He is satisfied that the marriage had taken place. And the residential certificate and the caste certificate, as he says, has never been challenged.
My lord, may I go? They have referred to my lord.
Referred to
There is a government
certificate.
There is a government guideline.
There is a government
Guideline that the residential certificate which has been issued by the Tahsildar, that is to be accepted. And in case any objection is raised, then it is to be verified by once again by referring the matter to the Tahsildar. Now this same has been conducted. it has been complied here after receiving the objection. Once again, the Tahsildar confirmed it.
That I have issued such a.
Yes, and once again, my lord, the petitioner, my lord, she raised some objection with respect to the, maybe with respect to the integrity of Tahsildar. Then once again, a joint inquiry was conducted. And once again, the same problem.
But Lord, I have already considered that unless it is
Yes.
challenged in a superior court of law, it cannot be.
No,
That is to be, that certificate has to be challenged within the four corners of that miscellaneous certificate.
Yes.
yes.
So that has not been.
Because there are two provisions in miscellaneous.
One review.
One review power is there, my lord.
I know. I've dealt with such a position in one of my judgments.
Yes.
Judgment. And will at the list of.
I could have invoked review power, or I could have even invoked the appellate power. Either or.
The list of valid candidates will already been notified, my lord. Only the sub collector is to go ahead with the selection process, and who will, my lord, come out meritorious will be appointed. That's the only thing.
Anyway, Mr. Nagda, your assistance may not be necessary.
My lord, only my presence
Not
may be
necessary
noted,
at
my
all.
lord.
He has been fair enough to say whatever is there on record.
My learned senior is already, my lord.
He is always fair.
My lord.
Whatever is there on record, we will pass that order.
My lord. Not just only with this fact that the list of valid candidates will already.
No, I will not pass any such order. I will simply say that I will not interfere. The petitioner challenges the order dated 27/6/2017 passed by the sub-collector Patnagarh in what is the number of the case?
That is Miss Anganwadi appeal case number 5 of 2015.
AWC appeal case number 5 of
At
2015.
the top, it is handwritten, madam.
My lord. Case 9, my lord.
The appeal was preferred by the petitioner challenging the selection of the present opposite party number 4 on the ground that she had submitted false marital status, as also and on the ground that she is not a permanent resident in the service area of the Anganwadi center. This court finds from the impugned order that the sub-collector, being the appellate authority, has taken into consideration the rival contentions and has also referred to the report of Tahsildar Patnagarh on the objections raised by the petitioner with regard to the residence and caste certificate submitted by the private opposite party. So further, a joint inquiry also appears to have been conducted by the Assistant Collector Patnagarh and SSSO Patnagarh. As such, the sub-collector has arrived at the finding that the opposite party number 4 was married to Santosh Suna of village Gondamel on 5/11/2011 and was also issued with a residence and caste certificate by the Tahsildar Patnagarh showing her marital status as such. Learned counsel for the petitioner has not been able to demonstrate as to how these findings of fact are erroneous so as to persuade this court to interfere. Stop. This being a certiorari proceeding, the writ court would be slow to interfere in the order passed by the quasi-judicial authority unless it is shown that the order is blatantly erroneous, perverse, or against the weight of evidence on record. Stop. Such is not the case here. As such, this court finds no reason to interfere with the impugned order. Stop. Resultantly, the writ application is dismissed. Yes.
Well, Lordship gives permits me. Can I say one more?
Yes, please.
Your Lordship, if your Lordship wants, your Lordship may add the line that certificates have not been challenged under the law.
I forgot to write that. Thank you. Further, there is nothing, there is no material to show that the resident certificate and the caste certificate were ever challenged by the petitioner before the appropriate forum.
But my presence can be noted.
সেটা উপরে লেখা হবে না?
Item 15. And the sub collector directed the CDPO to go ahead with the selection process. That may be
dismiss କରିଦେଲେ ଗଲା ସରିଲା ଆଉ କାଇଁ କଣ
ସେ already ଚାକିରି
ତାଙ୍କ ପିଟିସନ ରେ ଆପଣଙ୍କର କାଇଁ ଆପଣଙ୍କୁ ରିଲିଫ ଦିଆଯିବ
ସେ ଚାକିରି କରୁଛନ୍ତି.
no, କରିନି. The selection process has been stayed. That's
No,
the
no.
other terms.
Subject to result of the writ.
କିନ୍ତୁ ଦେଇନାହାନ୍ତି ମେଲଟ କେହି ବି ପାଇନାହାନ୍ତି ସି ମେ ଅଲସୋ ଗେଟ୍ ଆଇ ମେ ଅଲସୋ ଗେଟ୍ ଏନି କ୍ୟାଣ୍ଡିଡେଟ୍ ମେ ଗେଟ୍ ଦ୍ୟାଟ୍ ସିଲେକ୍ସନ ପ୍ରୋସେସ ଆଉ ସେମାନେ ଯାଇନାହାନ୍ତି ଆଫ୍ଟର ଦିସ୍ ୱାଜ ଚ୍ୟାଲେଞ୍ଜ
ଆମ ପାଖରେ ଯେତିକି ଥିଲା ଆମେ ସେତିକି କରୁ Yes.
To make a mention, Lordship, item 11, there is an interim order.
Interim order to continue. Item 11.
Obliged, Lordship.
item 15
May I please your lordship? The petitioner files this writ application challenging the inaction of the opposite party and the order dated 1/11/2019 under Annexure 7, where the entire selection process in respect of Lakshmipur village and for selection of Asar Karmi has been has been rejected. Entire police are found to be inappropriate and considering on it was null and void declared by the collector Devgar. The fact remains that pursuant to the advertisement that is under Annexure 1 on dated 10/8/2019.
Counter is necessary in this case.
After
Yes, Mr.
2020,
Mishra.
Millard, this is the first time. Millard, it is.
Yes, Mr. Mishra, counter is necessary in this case. I've gone through the impugned order, short order. Sri Patnaik Learned AGA undertakes to file counter within 2 weeks. Within 2 weeks. Less this matter, no, granted. Will July 1st karo, July 1st week. Yeah, I'm sure. On 1st August. Counter affidavit will be filed in the meantime positively. Yes.
item number 16
कौन order होता देखिए order sheet कहीं order sheet है चिरी गलानी है टाइप नहीं You are the district education officer. You are the district education officer. Why are you not complying with the order of the school? Yes, sir. Why are you not complying with the order of the school? Do you know that non-compliance of the order can have very serious consequences? But why are you not complying with the order?
It joined just 4 months ago. So
4 months. 4 months is a long time.
that's for the decision of Honorable Court. I will.
No. Why have you not complied it today? I will issue a contempt. I will issue contempt against you. And nothing. What is there in this affidavit? Please place this affidavit. What is the
On 25/6/2014.
25? Let me go through that order.
Yes.
It says that the first candidate selected for engagement under PH category never joined. So there was a vacancy. This is what he says. We do not know whether it is correct or not.
Yes.
That is why I wanted you to
Yes, ma'am.
submit why their vacancy was not filled up.
My lord, the fact remains, my lord, as it has been mentioned in the affidavit, my today's affidavit, that is a selection process of 2006-2007. Now challenging the same, my lord, he approached before this honorable court in 2009. This case was disposed of in the year 2012, rejecting his claim. Then he approached before the appellate court. Appellate court also confirmed the order of the
Appellate court means?
writ appeal.
Read appeal. Okay.
Writ appeal, my lord, that order was also confirmed.
Single judge's order was
Confirmed.
complied with. Yes.
And the case of the petitioner for his appointment against the recruitment year 2006-2007 that has been rejected. Then, my lord, he approached before the Chief Minister grievances. Thereafter, my lord, the matter was referred to the law department. In the opinion submitted by the law department in the year 2017, my lord, a decision was taken that taking into consideration the two decisions of the honorable courts on two different occasions, my lord, that his case with respect to this 2006-2007 cannot be considered. But since in the meantime, in the year recruitment year 2010, his case can be considered with certain condition that if he is otherwise eligible and other things matter. Then your lordship, on the first instance, when I was conducting this Matrimonial on behalf of the State Council, that lordship directed me to get that law department's opinion. That is also available in Annexure 7, my lord, in this case also. He has also filed, and we have also collected that copy. Thereafter, my lord, a stand has been taken by the petitioner, my lord, that the number one, because in instruction, my lord, we submitted it with your lordship, that there were 16 number of vacancies, including one post meant for physically handicapped category. And the petitioner is at serial number 2. But we didn't say anything in that particular instruction with respect to what is the status of that particular serial number 1 and whether that post was filled up or not. So, lordship, on 25/6/2024, on the basis of the submission made by the petitioner, that the petition, the serial number 1 in the merit list, though he was offered with the post, but
he did not join.
He didn't join. My lord, with the available materials on record, even though, my lord, yesterday.
Yes, so the law department always said that he can be considered in respect of the 2010 vacancies.
2010 vacancies.
In 2010, the first person did not join.
No. That is in respect of 2006.
2006. Okay.
So, my lord, 2010, my lord, another important point, my lord, 2010 selection, that was also quashed by this honorable court.
Okay.
So, a sequel in 2011, another advertisement was issued. And there were 4 number of vacancies meant for the PWD categories.
Sir, may I given 1 minute?
Four number of vacancies were advertised, and the petitioner did not apply for this.
All right, but I would like to know
only, my lord, may I permit, only last sentence, my lord. With respect to the query, as your lordship read in the order dated 25/6/2024, to file an affidavit with respect to the submission made by the petitioner, so far the joining of the serial number 1, my lord. I also verified the existing files, my lord, whatever it is available with the collector, the district office, my lord. Now, presently, also the DO is also looking after this matter. Previously, it was by the BDO. So, there, my lord, I didn't find any document with respect to that.
So, what stopped the education officer from saying so in an affidavit?
No, because, my lord, the original file with respect to that one, my lord, that is not till now, my lord, it could not be traced. So, my lord, with respect to all the information, what it is available, that we have indicated because it was in the form of instruction. So, another affidavit, my lord, after your lordship's order on 25/6 and 2/7, an affidavit has already been filed.
That I know.
On 5/7.
That I know.
Thereafter, my lord.
Even that affidavit was not found to be inadequate. That is why.
With this particular information, my lord, that was not there.
So yesterday, as Mr. Das was saying, he has asked for 2 weeks time. Why?
That was referring to the letter dated 1/7. And my lord, in the meantime, already.
So this cannot go on like this. This cannot go on like this. Whatever is your stand, you have to take a stand.
Well,
that has to be considered by the court while hearing the writ petition on merits. But you cannot stop the court from proceeding further. You could have said that earlier. You are a government officer. You have got. You have to give due regard to the order of the High Court. How can you stay so lackadaisical about it? There are consequences कौन अपन जानते हैं तो? Violation or non-implementation of the order of this court. How can you remain so silent? अपन जहाँ stand नंबर अच्छे अपन नहीं हो तो किसी माने whatever may be your stand. Whether the petitioner is ultimately, whether he is entitled to the relief claimed or not, is a matter to be decided by us. Nobody is asking you to straight away appoint him.
Yes.
You cannot paralyze the court. And this is a matter where the person is appearing in person. The petitioner is appearing in person and he is a physically disabled candidate. Yes, what were you saying?
Yes, sir. The additional government advocate has already said 1 minute before that the CORAM had not applied for the said post in the year 2011. Sir, take a read application once dekhantu, page number 39. OPEPA has already clarified that the CORAM had applied for the said post in the year 2011. Why this government advocate is betraying the letter of issued from.
Be careful about your language, Mr. Korav. Be very, very careful about your language. Odiyar kuhantu. Odiyar kuhantu, iti kon se okilon ko apna kichhi koi karibeni. Language ko carefully kotha karantu. Not sange sange court bahar kar debi. And I will take action against you. Sarkar okilon kare betray korchନ୍ତି boli. Kuhantu kon kohchନ୍ତି kuhantu.
Sir, page number 39 re achi sir. CORAM apply karthile boli achi.
Lekha is it clearly?
Yes.
Clearly, lekha CORAM had also applied for the said post during 2011. So why this mess? And now it is being said that he had not applied.
But they have specifically taken a stand.
How can they take a stand which is contrary to their own document? This is their document.
Yes, but submitted by.
Anyway, yes. I am directed will consider nahi.
Yes, yes.
है ना? वो पेपर लिखी नहीं दी थी 2011 he was an applicant. Shri CORAM has also applied for the said post during 2011. This is a very clear and positive statement. How?
May I refer to that instruction, my lord, which has been submitted by the government. There also, my lord, they have indicated that he has not applied.
Is it not contradicting?
Maybe, my lord, after getting this particular letter by the, it is from the OPEPA to government.
OPEPA to government.
So, even if, my lord,
and OPEPA is the best authority, is the most competent who can say.
With respect to receiving the application.
Application they not they OPEPA is a party here.
Yes.
Is OPEPA a party? So let him obtain.
Yes, yes.
Let him go and find out from OPEPA.
Yes, ma'am. Director elementary education and the collector, my lord. But because.
So let the district education officer.
I can also.
Let the district education officer.
Yes.
Let him find out. Let him submit a further report to this court.
On the.
Because apparent we have to resolve this apparent contradiction. ଆପଣ କହୁଛନ୍ତି ଯେ ସେ appeal apply କରିନାହାନ୍ତି ଆପଣଙ୍କ document କହୁଛି ସେ apply କରୁଛନ୍ତି.
28/7/2011.
Why will this poor man suffer? I don't understand. He is running to the court.
Yes.
Since so many years. Simple. You take a particular stand.
Yes.
That we will consider. See, we will consider that stand.
Yes.
If he is entitled to, he will get it. If he is not entitled to, he will not get it. That's as simple as that. But the stand appears to be very, very contradictory. Anyway, what is your name? Again? Sri Santosh Kumar Raut, the district education officer, come district project coordinator, Samagra Sikhya Katak, is present in court and files an additional affidavit in compliance to order dated 10/7/2024. It is inter alia stated in the affidavit that the select list pursuant to advertisement issued in the year 2006 was quashed by this court. And further, the recruitment for the year 2010 was also quashed.
Select list with respect to.
It is clarified here, advertisement made in 2010 for recruitment Shiksha Sahayak, which was quashed as per judgment dated 8th election.
Select 2006 tak was. Then it's a typographical mistake, my lord, if it has been stated.
Wherein inter alia it is stated that
2010 advertisement has been quashed as per the order of this honorable court. My lord, that is in pair number 3, para number 5.
Wherein it is stated that as per opinion tendered by the law department, the petitioner was entitled to offer himself as a candidate in terms of the advertisement floated in 2010. Stop. The advertisement issued in 2010 was, however, quashed as per judgment dated 29/6/2010, passed in WPC number 1361 of 2010, and a fresh advertisement was issued in the year 2011. Stop. It is further specifically stated that the petitioner had not submitted his candidature against such advertisement. As against this, Sri Srinivas Kaur, Learned Counsel, the petitioner in person draws attention of the court to the letter dated 28/7/2011 of OPEPA, of Deputy Director Bracket Administration, OPEPA, wherein it is specifically stated that Sri Kaur has also applied for the said post during 2011. A sentence within inverted commas. As such, there is a apparent contradiction in the stand taken by the state, as reflected in the additional affidavit filed by the DEO in the court today. The DEO is directed to reconcile the mutually contradictory pleas and to submit a report in this regard after making necessary consultations with OPEPA. Stop. It shall be specifically indicated whether the petitioner had actually submitted application pursuant to the advertisement issued in the year 2011. Such report should be filed before this court in the form of an affidavit by next week. Let this matter. I am giving you 2 weeks time on 25th July. Kora bujile?
Again, sir.
ବୁଝିପାରିଲେ
Yes, sir.
ଆପଣ କହିଲେ ଆପଣ ଆପ୍ଲାଏ କରିଥିଲେ ବୋଲି ସିଏ କହୁଛନ୍ତି ଆପ୍ଲାଏ କରିନଥିଲେ ବୋଲି
Again.
କରିନାହାନ୍ତି ବୋଲି ସେ କହୁଛନ୍ତି
ଆଜ୍ଞା।
ତେଣୁ ତାଙ୍କୁ ଆଉ ଥରେ ଡାଇରେକ୍ସନ ଦିଆଗଲା ଆପଣ ଓପେପା ସହିତ ଇଏ କରିକି ଆପଣ ଗୋଟେ କୋର୍ଟକୁ ରିପୋର୍ଟ ଦିଅନ୍ତୁ ପ୍ରକୃତରେ ଆପଣ ଆପ୍ଲିକେସନ ହେଇଥିଲା କି ନା କଣ୍ଟେଣ୍ଟ ରିପ୍ଲେ ହେଉଛି
Again.
କେମିତି ଫାଇନିଂ ଦେବେ
Again, again, again.
ହାଉ କ୍ୟାନ୍ ଦେ ଫାଇନ୍ ବୁଝିଲେ
Again.
ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି
Sir. That is next week ରେ କରୁଛନ୍ତି ନା କୋଉ
25
ନେକ୍ସଟ ୱିକ୍ ଭିତରେ ସେ ତାଙ୍କୁ ତ ଟାଇମ ନଦେଲେ ସେ ଖୋଜିବେ କି
ଆଜ୍ଞା
ଟାଇମ ନଦେଲେ ଖୋଜିବେ
25 ଜୁଲାଇ
ଏତେ ଦିନ ୱେଟ୍ କଲେଣି ଆଉ ୱେଟ୍ କରିବାକୁ ପଡିବ କଣ
ଆଜ୍ଞା
The affidavit be kept on record. The personal appearance of Sri, what is your name?
Santosh Kumar Raut.
Sri Raut is dispensed with for the time being. He shall appear in person with the report on 25th of July. Yes. Please give due regard to the court, to the High Court. Well, it could be very, very dangerous. Yes.
Item number 17.
May I please, your lordship? But here. Lord, here the petitioner before your lordship was appointed as Yogan Sahab in the year 2013, 18/5/2013. He was engaged as a Yogan Sahab.
Yes.
My lord, till the year 2022, everything was running very smoothly. My lord, there was never any allegation during these around 10 years. My lord. Now, in 2022, my lord, the new elected body of the Gram Panchayat came, my lord. My lord, thereafter, all the problems arose. My lord, the Sarpanch, he started demanding some amount from this man, my lord, which he refused, my lord. Therefore, my lord, they deliberately tried to, my lord, disturb this petitioner, my lord. And the first occasion in the year, in the month of June 2022, my lord. My lord, the Sarpanch directed the PEO, Panchayat Extension Officer, to lock the Godam, my lord. So Godown was locked. Therefore, my lord, the materials could not be properly distributed, my lord. So a so-called notice was issued to the present petitioner, my lord. I submitted the so-called reply, expressing, my lord, everything, my lord, that these are the things for which the distribution could not be properly made. My lord, there was an inquiry on the basis of that, my lord. Now, in the inquiry, my lord, the PEO was found guilty and he was, my lord, put to penalty, directing him to pay 5,000. Whereas the present petitioner, against him, my lord, 500 was fine was imposed, my lord. I paid the fine, my lord. That is by order dated 26/7/2022, my lord. Your lordship will find that is available in the reply to the additional affidavit which I have filed, my lord. Lordship got it.
Yes. Annexure?
Annexure 10 is the order, man. Annexure 9 is my so-called reply, my lord, where I have specifically said the Sarpanch has locked the Godown with his keys and not allowed me to the Godown. Just before inquiry, he opened the Godown so and so, so and so. So, my lord, thereafter the order was
You were imposed,
is directed
you were imposed with fine of rupees 500.
5,000. I was imposed with fine of rupees 500 because of some, my lord, cleaning and other things are concerned, my lord. Those are for that purpose, my lord, 500 was imposed, my lord. My lord, after that, he got the Sarpanch again got very furious, and he set the Samiti Sabhya to lodge an FIR in the police station, my lord, basing on which, my lord, the Samiti Sabhya, she lodged an FIR. Your lordship will find in my writ application at annexure 4, my lord. This was lodged on 21.
Yes, I got it.
Yes, my lord. Now, in this case, I was arrested, my lord. I put behind the bars, my lord. For around 10 days, my lord, I remained inside the custody. During those period, my lord, I could not distribute my lord, materials. So, my lord, so-called notice was issued to me, my lord. I gave a reply. Without conducting any inquiry by the impugned order at annexure 5, my lord, at page 17 of my writ application, my lord. I was thrown out of the I was terminated.
What has happened to that case?
My lord,
what has happened to the criminal case?
Criminal case is running, my lord. That is pending. My lord, now by this letter, he has thrown me out. The Sarpanch has thrown me out, my lord, even without taking approval of the ଆପଣ ଜେଲ କଷ୍ଟଡିରେ ଥିବାରୁ ଖାଉଟି ମାନେ ସେମାନଙ୍କର ସାମଗ୍ରୀ ପାଇବାରୁ ବଞ୍ଚିତ ହୋଇ ପଞ୍ଚାୟତର ସରପଞ୍ଚଙ୍କୁ ଜଣାଗଲା।
that is, but by then, my lord, 90% distribution was already
Why
completed.
did you file an appeal before the collector? I think
Appeal ଟା ଏଥିରେ against appeal ହବନି ବୋଧେ।
GRS ରେ ଅଛି ଯୋଗାଣ ସହାୟକ ଅଛି ନା ଅଛି ବୋଧେ ଗୋଟେ appeal ଅଛି।
2016 guideline, my lord, that.
No, it is 2022 order. There is a I think an appeal.
Yes, ma'am.
And this honorable court, your lordship will find, my lord, this honorable court by order dated 29/11/2023 had directed the state
file the inquiry report.
to file the inquiry report. They have not filed the inquiry report as it relates to the present proceeding, my lord. That regarding this termination, my lord.
You first find out
They filed the inquiry report of the previous.
I know, but you find out what is the provision. Find out the guidelines. We'll take it up next week.
Next week.
Huh? If appeal remedy of appeal is there, why will this court enter into that?
I will have to also check up, my lord.
Please check up. There is a revised guideline. Probably there is an appeal.
I'll find out.
Gram Rozgar. You are Jogan Sahib, nahi?
Jogan Sahib. Probably for Jogan Sahib.
Probably before the collector and the collector's order before the director special projects. এটা নয় কি গ্রাম রোজগার সেবক भी ହେଇଥାଇ ପାରେ. So these are very confusing.
Here, my lord, no inquiry has been conducted.
No, but
Straightway, my lord, so cause notice was issued, I gave a reply and they threw me out. Even though, my lord,
Who is appearing for the Sarpanch?
My lord, I am appearing on behalf of Mr. Achari for the Sarpanch, my lord. Lordship, we have filed our counter on 29th of October 2023 and we were given intimation from the office of the Panchayat Samiti on 21st of December 2022 and therefore we were instructed to take in immediate action. Now the government, your lordship, has also averred in its counter about the fact that earlier a penalty was imposed and thereafter, my lord, a resolution was called for a meeting of the important members of the Gram Panchayat.
Now, how is the previous that penalty? How is it relevant?
My lord,
how is it relevant in this case? This is a separate case.
Yes,
this is a purely.
No, my lord. What has happened is
the allegation against him is that he did not distribute the food grains to the customers.
Yes.
For that period, and he says that I was in jail custody. I could not have done that. That's a very viable, valid reason why he could not distribute the food grains.
My lord, apart from that, what has happened is that also, apart from that also, my lord, the petitioner was also guilty.
No, supposing he is found, he is acquitted from the criminal charge.
My lord.
He may be acquitted.
Yes,
it's just
absolutely.
a case.
Absolutely.
It's just a case. It's just an allegation.
Yes.
FIR, maybe a charge sheet may also have been submitted, but that doesn't make him guilty. He's facing trial.
My lord, apart from that,
so he has a valid reason for your only case is that he did not distribute the food grains during that period. That is the only ground.
Yes.
And he has a plausible and valid reason. Because he was inside jail custody, how could he have distributed? Yes, Mr. Patnaik, you find out.
Yes,
list this matter next week.
19th July.
19th July. The counsel for the parties shall address the court as regards alternative remedy against the impugned order.
Yes.
Yes.
At number 18.
बंद करिए और कौन करें? लास्ट कितने अच्छे? वो कोड़े जाए अच्छे अच्छा हो कोड़े जाए कि बंद करिए. Item 18.
Lordship, item 18, Lordship, on the last occasion, Lordship had filed amendment of my prayer portion, Lordship. Lordship had allowed. Sorry.
You filed the consolidated?
My lord.
Yes.
I have also served a copy on my.
Yes. What is this matter?
Lordship, in this case, Lordship, the petitioner has challenged selection of the opposite party.
2023 matter, will take it up in month of August or September. We'll take it up in August.
That's a very simple thing will be decided by your lordship.
What?
Whether I belong to that area, whether the Anganwadi center is located or not. On that ground, I have been rejected that I don't live in that particular area in which the Anganwadi center is situated. That is the thing, lordship.
So how can this court find out whether you are...
Lordship, as per the resident certificate, I am a resident of that area. I am
of that village.
That's a village area at where the Gambarigoda 1 is the center, and I am a resident of Gambarigoda 1. I have also annexed that lordship.
I don't know. There are two things. First is the revised guidelines of 2007. 2007, followed by 2008. In 2007, it says village / Anganwadi center, center the service area. In 2008, it clarifies that it has to be service area. So, what is your case?
Lordship, threefold prayer, Lordship.
Did you not file any appeal?
Lordship, appeal filed before the ATM.
So that is what is challenged.
My lord.
Lordship can call for the record so that the entire report has.
On 4/7/2023, it was directed.
Why?
This court, Lordship.
Why you see that other matter, Mr. Bose? Again, the same thing, certiorari. Why should the court interfere unless you show that the order is blatantly wrong or something like that?
Lordship, Lordship, I am challenging the ATM's order, Lordship. The fact is, Lordship, the ground taken by the petitioner in appeal has not been dealt with by the ATM, Lordship. Lordship, the fact is the authority delving into this matter, he has completely relied upon the paraphrase comments of the CDPO, whose order we are challenging before the ATM. So the ATM has not applied his independent mind and has relied completely upon the report of the CDPO, Lordship. And my submission, Lordship, is the order of the appellate court suffers from severe infamy in view of the fact that he has relied completely on the report of the CDPO. No independent inquiry or survey has been done, Lordship. Lordship, I take the Lordship to that relevant page, Lordship.
You filed your counter?
No counter has been filed, but the records have been received.
All right, we'll consider it. Is this matter? Hello?
8th August.
8th August. 8th August. Yes.
Item 19.
Mr. Raut in August 2024 matter. Item 20. Same. We'll take it up in the month of August 2024 matter.
Yeah, already 2 times it has been adjourned, and for 2 years he has been disengaged, my lord.
Put a date, cut the short date.
1st August.
1st August.
First of
Please this matter on first.
Item 21, specifically adjourned for today, my lord.
Yes, I'll take them. After launch. After launch, we'll take it. Our side is there.
Our side. Yeah, Asinuthle Kalibuli.
Item 33. That AD not back, my lordship can take up any other day, my lord. Voting either AD not back, but tracking report is there. I am for the petitioner.
I'll have to see that. The order they are tracking.
We'll take it up, Mr. Das. It is as it is laying.
Who's appearing for the other side?
Other side has some not.
Nobody is appearing. Will allows?
Sure.
Sri Raghunath Asmapatra, Learned Counsel for the petitioner is present. None appears for the opposite party, despite repeated calls. Yesterday also there was no appearance from the side of the opposite party, for which the matter was adjourned to today in order to give another opportunity to him to appear. So, since there is no appearance and the matter is of the year 2020, without keeping it pending, it is taken up for hearing. The petitioner wife seeks transfer of
CP case number 947/17.
CP case number 947 of 2017, pending before the learned judge, family court. Family court, that the dita court, na? 1 and 2.
17 ଗୋଟିଏ ଥିଲା କି ଯୋଡେ ଥିଲା ଆଉ ତାକୁ ଭୁବନେଶ୍ୱର 1 and 2
Aja who? Judge Family Court Bhubaneswar.
ଭୁବନେଶ୍ୱର ଖାଲି ଲେଖା ହେଇଛି
2. The Court of Learned Judge Family Court Barampur. Therefore, transfer has been made on the ground that the petitioner is presently residing at Polantara in the district of Ganjam, which is at a distance of
more than
nearly 200 kilometers from Bhubaneswar. As such, it would be inconvenient on her part to travel to Bhubaneswar to attend to attend the court on the date of posting of the case. After considering the submissions and the ground cited for transfer, this court is inclined to accept the same as a valid ground for transfer. Stop. The application is allowed. It is directed that the proceedings and such be transferred.
Item 22.
Your lordship had directed for service of notice through IIC Valianta PS. Now he has reported that he is no longer residing under their jurisdiction but under Pahad police station jurisdiction. That is the information received by.
So we'll send it to Pahad police station.
Yes, that's for your lordship may direct that.
The IIC of Valianta police station has informed that the address of the opposite party comes under the jurisdiction of Pahad police station. In such view of the matter, the State Council is directed to get the notice served through the IIC of Pahad police station, indicating that the matter shall be taken up for hearing on August. On 1st August.
Lord, I am for the petitioner wife, my lord. More than 3-4 days already passed.
कौन करे कौन notice है service बंद.
Yes, sir.
Madam, pardon to mention, madam. Item number 20, interim order to be continued, madam.
Item 20.
Last time also was not continued.
Interim order to continue. Item 20.
Item 20.
Item 23.
May I please, your lordship? We are saying may I be permitted to submit, your lordship. This matter, your lordship, the transfer of the 1cc case pending in the SDGM before the SDGM Malkatagiri to Hindol, your lordship. The lordship has heard the matter extensively. The convenient of the party has to be looked into while your lordship will exercise the power under section 407. Your lordship, it is in the
same be kept on record. Have you served copy?
Yes, your lordship. Copy I am serving.
Yes.
After 19th.
19th.
19.
Item number 25.
In this case, wife has filed the present application.
Is this your matter, Mr. Prusi? I don't think this is your matter.
25, my lord, item.
25.
25.
24 ta kaun hai?
24 ta sir, already action.
Oh, yes.
My lord.
Yes, Mr. Prusi, what is this?
Because as there was a chance for reunion, so the matter was referred to the mediation, and 3 sessions has already been over. There is no chance of any mediation.
The mediation final report has not been submitted.
Has not been submitted. The date has been fixed to 15. So this matter be listed any date.
15th of August?
No, my lord.
15th of July, I mean.
July.
So we'll take it up thereafter?
Thereafter, my lord.
Sri Prusti Learned Counsel for the petitioner submits that the next date of mediation has been fixed to 15th. List this matter on
25th July.
25th July.
My lord.
Item 26.
May I please? Here the wife seeks transfer of the case pending in the court of Judge Family Court Ganjam at Barampur to Bhubaneswar.
Ganjam to Bhubaneswar. Yes.
Yes, I'm for the husband, my lord. My lord, one of the DV case, right, MC 238 of 2022 already pending before the.
That has a TRP channel has been filed here. That is also
that's
pending.
not disclosed before this.
So let us bring it.
পরে ফাইল হয়েছে এই ফাইল পরে সেটা ফাইল হয়েছে
ঠিক আছে কিছু অসুবিধা নেই nobody is accusing you of withholding facts. Let us bring that matter also to this.
Yes.
ডিফেক্ট আছে বলে লিস্ট এই পারলাম ঠিক আছে
List this matter next week along with
The TRP D number 7147.
TRPC.
TRP CRL.
TRP CRL number.
That's a D number. Defect number. Diary number. Sir.
You get the defect removed, then we'll list it. Learned counsel for the petitioner informs that another application has been filed seeking transfer of the domestic violence case pending at Koti Bhubaneswar.
SDGM Barampur.
SDGM
Barampur.
Pending before SDGM Barampur. But the same has not been listed because of non-removal of defects. He undertakes to remove the defects and to make a motion for its listing along with the present application. List this matter on 25th July.
Interim order to party.
Interim order to party.
Public.
Item 27.
Item 27. Sure.
Item 28.
And wife has filed its application seeking transfer of
Mediation has become unsuccessful. The report of the mediator indicates that mediation between the parties was unsuccessful.
Yes, ma'am.
The transfer application is therefore taken up for hearing. Go to Indore, Talcher.
Talcher. That is around 75 kilometers, ma'am.
What a middle plus ongoing is a family court judge. It will be convenient for all the parties.
Yes, what do you say, Mr. Pradhan? Not a bad suggestion.
Reading at Talcher.
Talcher, Onugul, 40 kilometers. 40 kilometers.
40 kilometers, but she's not yet getting any maintenance, ma'am. And he has not also filed a maintenance. And therefore.
Maintenance by transfer application to order pass kari.
No, I am not. Because he is not sufficient means to.
You wanted to be transferred to Talcher.
Talcher.
If it is transferred to Onugul, I don't think you will be under any sort of inconvenience. It will not be inconvenient.
And your lordship may say also that he will bear the costs to and fro.
Therefore, transfer has been made. This is an application for transfer on behalf of the wife of MAT case number 1 of 2024 from the Court of Learned Senior Civil Judge Hindor to the Court of Learned Civil Judge Senior Division Talcher. Therefore, transfer has been made on the ground that the petitioner is residing at Talcher and has no means to maintain herself. It would therefore be difficult on her part to travel to Hindor on the date of posting of the case. Sri Naik, learned counsellor for the opposite party, husband, submits that it would be convenient for both parties if the case is transferred to the court of the Judge Family Court at Onugul. On query by the court, he submits that his client would be willing to pay the to and fro expenses, bracket bus fare, to the petitioner for traveling to Onugul from Talcher. Such being the submission, the transfer application is allowed. It is directed that MAT case number 1 of 2024 pending in the Court of Learned Senior Civil Judge Hindor shall be transferred to the Court of Judge Family Court Onugul. Sorry, the opposite party husband shall pay the actual travelling expenses, that is bus fare, to the petitioner wife on the dates on which she is required to attend the court personally.
Item 29. I am pleased, Your Lordship. I am for the petitioner wife, Your Lordship. Petitioner residing at Cuttack in his uncle's residence, whereas the husband is the at jurisdiction of the Jaspur, Your Lordship. He had filed.
Yes.
May I please, Your Lordship?
You are the wife.
I am the wife. And petitioner husband is working as a CRPF grade 1 constable residing at Jaspur jurisdiction, family court Jaspur. He have filed already.
Delhi.
406 has CP 406.
Case is pending at Jaspur. You want it to be transferred to Cuttack.
To Cuttack.
What do you say, Mr. Naik?
Objection. Petitioner no objection.
The petitioner.
Mediation fine.
Honestly speaking, what I have told from the petitioner, also cousin of me, he had filed restitution to consulate at the Jaspur jurisdiction, Your Lordship. So, let to transfer this matter to here or mediation in High Court. Mediation, it is better because restoration of family, some small child is there.
Yes, certainly. In course of hearing, it is stated at the bar that an attempt can be made to resolve the dispute between the parties amicably through the process of mediation. Mediation order. Is this matter on?
Petitioner is posted at Delhi 1 month. Chutita nahi se asibo.
September post karo.
September 9th September.
9th September. Purvur lakhantu. Since the opposite party is posted at Delhi, the mediator shall fix a date, giving giving adequate time for him to appear.
Your Lordship, the CP 406 kindly no coercive action.
Stay kar den sir.
Stay गोटे petition file करें.
नहीं, मु तो जानती माने ये जो बोली transfer है जो बोली, but provided yesterday what he is telling, what she is telling is also interested for the restitution consulate because small boy is there. That's why no coercive action.
Since this court has referred the matter to mediation, the proceeding in the court below.
Right, CP number 406 of 2023.
CP number 406 of 2023.
Learned Justice Family Court Jaspur.
No coercive action shall be taken against the petitioner. Since the matter has been referred to mediation, no coercive action shall be taken against the petitioner in the meantime. Yes.
Sorry, my lord. Item 23, interim order to continue.
Item 23, interim order to continue. Yes. Item 30.
I please your lordship. My lordship, I am on behalf of Contempt Council SAU. My lordship, after admission, notice has already been issued, but the opposite party does not intend to appear in the back date.
The notice has been. Is the notice sufficient?
Yes.
Office note indicates that notice on the opposite party has been duly served. There is, however, no appearance on repeated calls. I will time the bar in order to grant one more opportunity. Place this matter
25th July.
On 25th July. Interim order to continue.
Interim order.
Item 31.
The petitioner is my lord wife, my lord. Today's morning, my lord, one advocate has called me to appear on behalf of the husband, my lord. Let it come, my lord.
My lord. List this matter on 25th July.
Item 32.
My lord. The petitioner is the wife, my lord, of the husband, the opposite party is the husband. And wife has filed a case on 125 CRP petition before the Raurkela family judge. And
you want it to be transferred from Raurkela to Puri?
Puri to Raurkela. Allowed.
Who's the other side?
My lord,
yes, what is your stand?
My lord, prefer 2 weeks time for the return.
2 weeks time for what?
For the filing the written submission.
What written submission? What is your stand? Are you opposing the transfer or proposing the transfer? Let us grant him one opportunity.
My lord, first week of August, my.
All right. Learned counsel for the opposite party seeks an adjournment. List this matter.
8th August.
8th. List this matter on 8th August.
Item 33.
The wife is petition before lordship seeking transfer of the proceeding pending before the judge family court Bhavani Patna. The court of judge family.
All right. The postal tracking report indicates that the notice on the opposite party was duly delivered. There is, however, no appearance on repeated calls. In order to grant one more opportunity, list this matter on
1st August.
1st August.
Malad stay for the proceeding.
Interpreter କିଛି ନଥିଲା
Adjournment petition ଦିଆଯାଇଥିଲା.
ସେଇ adjournment କର
Interment continue malad.
adjournment
Interment continue.
ସେଇଟା adjournment ତ
Item 34.
Lordship, I may pray for 2nd of August, my lord. I may be not able to 2nd August.
8th August.
I am appearing for opposite party member.
My lord, the petitioner is the wife before my lordship seeking transfer of the CP proceeding from the learned judge family court Baleshwar to learned civil judge senior division Rajgangpur.
I am for the husband, my lord, opposite party.
Sri S.S. Mahapatra has entered appearance for the opposite party by filing Vakalatnama in the court. The same be accepted? Yes.
That the wife is seeking transfer of the CP, that is civil proceeding from the learned judge family court Baleshwar to learned civil judge senior division Rajgangpur.
Baleshwar to Rajgangpur. On what ground?
On the ground that she has been deserted since long.
No. On what ground is she seeking the transfer? Transfer kahin chahunchandi?
Because of the first is the distance. The distance.
So she is residing at Rajgangpur. Say that. Say that. Yes. What is your?
Maybe refer to the mediation.
What do you say about mediation?
Lordship, if mediation may be conducted, if conducted, then it may be, if so possible, then it may be at Rajgangpur.
Distance, my lord, 400 kilometers.
Where are you residing?
At Baleshwar, my lord.
No, it will be difficult at Rajgangpur.
The lordship may only at a High Court mediation center.
Right.
Mediation no problem. High Court mediation. जहाँ लिखा दिया प्रथम गति. Does this matter? Mediation में order है गला.
22nd August.
22nd August. Interim order अच्छी.
Yes, sir.
कौन? Adjournment.
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 Okay.
Item 35.
Filed a modification, my lord. Regarding the two solvent security of 2 lakhs along with one of the family member. Lordship, earlier co-accused has been released on only 2 solvent securities. And Lordship also directed the similar orders. But importantly, the one of the family member has been
Yes. So why?
Lordship, earlier order is there, my lord. I have Annex 2. Lordship has directed similar order, my lord. And these petitioners, family members have no property at all. So he could not able to release my lord till 24/4/2020. Lordship has directed in the open court that similar order may be passed. But
similar order to what? Annex 2?
Regarding this security, my lord. I have annexed the order, my lord.
Where is that order?
In respect of co-accused, Mansur Alam.
I
have annexed that order.
12,984.23.
No. This was family member କଥା ତ ନଥିଲା. ଏଥିରେ ଏଇ order ତ ନାହିଁ.
ଏ order ନାହିଁ, ଆମ order ରେ ଅଛି.
ସେ deliberately ରଖା ହେଇଛି. Deliberately ରଖା ହେଇଛି ନା ଆଉ.
No. Lordship has directed to same order.
Because he belongs to Bihar. That is why that order was passed.
He is also outside.
Mansur Alam. No, that is why. Otherwise, he will go away and he will not come.
He is appearing, my lord, after getting the instruction, lordship has passed the order. And he has no property at all. And he could have-
Yes. Therefore, modification has been made to waive the condition of furnishing one family member as a surety. Stop. It is submitted that the family members of the petitioner are not capable to furnish surety for the amount stipulated by this court. As a result, despite being granted bail by order dated 24/4/2024, the petitioner has not been released. Stop. Since the condition imposed is standing on the way of the petitioner being released on bail, this court is inclined to modify the same. It is directed that the court below shall release the petitioner on interim bail for a period of four months from the date of his actual release in the aforesaid case on furnishing bail bond of rupees 2 lakhs with 2 local solvent sureties, each for the like amount, to the satisfaction of the learned court in session over the matter. All other conditions except the condition of one of the surety being his family member shall remain intact. Yes.
Please. Item 36.
Item 36 is disposed of case. Your lordship has granted 1 month interim bail.
Yes.
And
Why has this come?
ଗୋଟେ interim bail ଟେ application ଟେ ରହିଯାଇଥିଲା ବୋଧେ pending.
Not press କରିଦିଅନ୍ତୁ. This has been called bail na
bail.
IA 290 of 2024 dismissed as not pressed. Yes.
Item 37.
Yes. Yes, sir. My lord, in the item 37 and 38, lordship, I have already filed by Vinama, but it's not reflected in the cause list. Anyway, lordship, there are 5 accused person in this case. I was apprehended on the month of May, lordship, 20 May 22, and I'm in jail from last more than 2 years and 2 months. And one co-accused has been on interim bail twice, and some direction has been passed by the Honorable Supreme Court, which I have filed, lordship. I am seeking liberty not to read it. So, in the backdrop of the release of the accused, one co-accused on interim bail, I am just humbly praying for the release of these 2 accused persons also. Out of 18, only 1 witness has been examined, lordship.
Since when are you in custody?
Lordship, from the month of May 22.
May 2022.
May 2022. All right.
2 years and 2 months.
All right. The court below is directed to submit a report of the showing the status of the trial. List this matter. August.
Lordship, any short date, please. If it's feasible, otherwise.
No. Let us first know the status of the trial,
Yes,
then
Lord.
we will consider.
Yes, Lordship.
On 1st August.
I'm obliged.
Yes.
I'm obliged, Lordship.
38 the same.
Yes, Lordship. Yes, Lordship.
Same. The name of Sri Sham Manohar, who has appeared for the petitioner, be reflected in the cause list. Have you taken consent of the other previous counsel? All right.
Yes, Lordship. Yes, Lordship.
All right.
I'm obliged, Lordship. Deeply obliged.
Item 39.
There is an application for extension of the bail order.
This is for the first time?
Yes, Manoj.
All right, 2 weeks.
Item 40.
Earlier, my lord, has in ABL appeal,
23, my lord, granted to surrender and move for bail.
First or second order itla.
First or second, in I have filed the IA going for 2 grounds. In the meantime, during investigation, 307 and 313 has been wiped out. That may be taken into consideration. That was
307.
307, 313 has been
All right.
correct. Both deleted.
Considering the submissions, the prayer for modification is allowed by adding the following at the end of paragraph 4. The courts below shall take note of the fact that the offence under section 313 and 307 of IPC are said to have been deleted in the charge sheet.
मैं charge sheet है लिखी चल I may note here that during corruption as per
forwarding report re?
Not forwarding.
not forwarded during
Supervision.
supervision.
Have been deleted in the supervision note. Yes.
Extension
2 weeks for the time.
and the connected case not placed on 2020.
Connected case to nahi ithre? There is no connected case.
No.
Item 41.
Okay.
My lord, the petitioner's bail application was allowed. One of the condition was, if it is clarified that this order shall be operative only if the injury sustained by the injury is found to be simple in nature, my lord. My lord, the injury, I have annexed the injury report. Out of 18 accused persons and 12 have been filed this bail application, and one of the injury is sustained grievous in nature, that is papuli ro hada fati jaychi. Papuli hada. Hato papuli.
Hato papuli hada grievous na?
Injury is minimally displaced traverse fracture of left bone of first metacarpal.
You declared? Kete kotha lekha hai? What, Mr. Patnaik?
That is not a vital part of the body, man.
Kono hatota vital nue? Aja hatota vital nue? Apna without hato apna kon kariye? ना आप कौन है
there is 18 जन, there is no specific allegation.
18 जन मिसिक तक मारले से लोगडा को
18
हां नहीं माने आपण 18 जन लोक मिसिक मारले बोले आपण तो निजे कहउछन मु तो
18 जन सेतरो माने बाउंड्री डिस्प्यूट मारले and
therefore modification is allowed. It is directed that the last sentence of paragraphs 5 be deleted.
Item 42 extension of time is
Sorry, paichin to 1 week extension, 1 week time. Agur thora nei chin mu dekh saleni.
ठीक है
nei chin देखो भाई ऑर्डर बोधे हेछि ना नहीं हेनी नहीं ना केबे 2 weeks दिया है टाइम 4/12/2023 रे तो 1 week time is allowed.
आगे
Item 42 on behalf of Mr. Paul Pastor is just
All right.
Item 43. And prisoners. There were petitioner languishing the jail custody from 6/12/2021.
You have the case ready?
Yes, madam.
And in the meantime, investigation has been completed and charge sheet has been filed. And her allegation
Rajesh Pradhan
against unknown person, my lord. FIR was lodged with an allegation that on 6/12/2021, while the nephew of the informant, along with Rajesh Pradhan, were returning to the home in a murder.
same order karo.
No, madam.
Hoga
It is on different footing.
different footing.
Different footing.
Let us see let us see the statement.
Rajesh Pradhan statement.
Let us see the statement of Rajesh Pradhan.
That Sagar Sahu, Birendra Pradhan, Akash Parida, only they restricted only movement tara courtly deceased. And one Muralidhar Sahu is on 120B. And this this
no
person
person was present. Petitioner was also not present.
Let us see the statement.
Yes.
Rajesh Sahu.
In FIR and my lord statement.
आपको नहीं कि राजेश
Two unknown person came from the court side.
देखिए
And
Rajesh Pradhan.
and one sword and pistol has been seized on behalf of the last 4-5 lines.
these those who have my lord, allowed my lord, they have also present and followed. And when they stopped them and also assaulted, two person came from the roadside and assaulted. Unknown person. He has not specifically stated anything that only because he has some personal enmity with the petitioner.
ଟିକେ ରୁହନ୍ତୁ ମୁଁ ପଢୁଛି ବା Mr. Mishra, read it.
ନାଇଁ ତାଙ୍କ ଡାଇରେକ୍ଟ କହିନି କିନ୍ତୁ
ନା ସେ କହିଲେ ଦେଖନ୍ତୁ ଧରିଥିବା ଖଣ୍ଡାରେ ମତେ ଗଲା କିଛି ବୁଝିବା ପୂର୍ବରୁ ବିଲର ଦୁଇ ପଟରୁ ଦୁଇ ଜଣ ଲୋକ ବାହାରି ଆସି କହିଲେ ଯଦି ସିଏ if he says that this
କହିଲାନି ଦି ଜଣ ଲୋକ
ଟିକେ ଆଜ୍ଞା ଆପଣ Mr. Bhaduda, please rest. Please rest. Be comfortable. Are you comfortable?
That injured might have been scared, my lord. 13 injuries.
No, let me read. You compare the three statements. First କହିଲେ ଭିକପଡା ଗ୍ରାମର ସୁରଜ ଦଳି the petitioner.
Yes, my lord.
ଓ ଖୋଜପଲ୍ଲୀ ଗ୍ରାମର କୃଷ୍ଣ ପାଣ୍ଡି ମିଶି ଜୀବନ ମାରିଦେବାକୁ ଧମକ ଦେଉଛନ୍ତି. So he knows କିଏ କାହାକୁ ଧମକ ଦେଇଛି, he is very clear.
Yes, my lord.
ଏଠି କଣ କହିଲେ ଖଣ୍ଡାରେ ମତେ ଅଘରୀ ନାୟକକୁ ଆତର୍କିତ ଭାବରେ ଆକ୍ରମଣ କରିଥିଲେ. ଏଇ ଯୋଉ ଦୁଇ ପଟରୁ ଦୁଇ ଜଣ ଲୋକ ବାହାରି ଆସିଲେ. ଯଦି ଏମାନେ ଥିଲେ ସେ ଜାଣିଥିଲେ ମୁଁ ତାଙ୍କୁ ନା କହିନଥାନ୍ତା. ତାପରେ ପୁଣି ପଛରେ କହିଲା ପୂର୍ବ ଦିନର ଶତ୍ରୁତାର ରାଗ ରଖି ସୁରଜ ଦଳି ଏଇଟା ଗୋଟେ କଞ୍ଜେକ୍ଚର ହେଇଗଲା. He may have been involved, but his statement,
his disclosure statement, 2 swords and 1 pistol and 2 and antecedents are there 302, 307, 326 and 19.
307
302.
307
326 Arms Act.
399 420. ସେ ଗୋଟେ antecedent. ଆଉ ଏଇଟା ତ ଦିଟା one antecedent, that is 307. Data mistake selection.
736.
Mistake selection.
Acha.
So confessional statement ର ତ କିଛି ମାନେ ନାହିଁ.
No.
So where is the evidence?
ସେତିକି
See, he may have been involved, but the evidence is not completely lacking.
Stringent condition.
The petitioner is in custody since
21/10/2023.
21/10/2021 in connection with such and such case. It is alleged that the petitioner and one Krishna Pandi had threatened to kill the deceased because of prior enmity. Subsequently, being associated with the other co-accused persons, they assaulted him brutally by means of sword and other deadly weapons. Prosecution heavily relies upon the statement of one Rajesh Pradhan, who is also one of the injured witnesses. Perusal of the statement of said Rajesh Pradhan, recorded under section 161 of CRPC, prima facie does not reveal confidence, as even after referring to the petitioner and said Krishna Pandi and their previous enmity with the deceased, he refers to the assailants as simply as two persons without stating their names. Further, he has referred to subsequently, further notice, subsequently, he has stated the names of the petitioner and said Krishna, referring to their prior enmity and the threat given out by them on the previous day. Correct. Learned State Council has opposed the prayer for bail by submitting that the evidence regarding prior enmity shows the motive. And secondly, the petitioner, while in police custody, gave recovery of the weapon of offense. After considering the rival submissions and on going through the materials on record, including the statement of Rajesh Pradhan, this court finds that save and accept the reference to the previous, to the threat held out by the petitioner allegedly on the previous day, and his confessional statement under section 27 of the Evidence Act. There is no acceptable or admissible evidence showing his complicity. Under such circumstances, I am inclined to allow the prayer for bail. Let the petitioner be released on such and such conditions, including the Kolligod police station on every Sunday at 10 a.m. for a period of 6 months. Next, he shall personally appear before the court in session over the matter on each date of posting of the case without seeking representation through counsel. In case of even a single default, the court below shall issue NBW to take him into custody again. Item 44.
My lord, 20B to C, 28 pages 700 grants. Petitioner is in custody since 18/9/2023. And in the meantime, trial has not been commenced.
Kete kg is 28 kg.
28 pages 700 grants.
The petitioner is in custody since
18/9/2023.
18/9/2023 in connection with such and such case. It is alleged that the petitioner and two other persons were transporting contraband ganja weighing 28 kgs, 200 grams. 700 grams when they were detained by police. So it is submitted that despite being in custody for more than a year, trial is yet to commence. So, taking into consideration the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released.
Oh, bless.
Each day appearance.
Item 45.
May I please, Lordship, petitioner was released on interim bail by the order dated 11/6/24 in IA 664/24 for 3 weeks.
In this case,
Lordship,
order sheet kichhi nahi.
5761 BLAPL number.
Yes, yes.
BLAPL number 5761.
ये देखते कि
5761.
हाँ 5761 तो
Aye.
ये इधर रिलीज नहीं थे
हाँ.
order sheet does not show anything.
IA number
ना IA number है तो order sheet देख लो फाइल टा बाहर करो हर फाइल टा ये 2024 तो नथियो देख लो order sheet देख लो
I have checked. ଦେଖିଥିଲି ସକାଳେ
नहीं हम order sheet कहीं नहीं
ନା
सीधे हम खोज so what happened?
Lord, he has been surrendered duly after expiry of 3 weeks, but certified copy of that surrender order I have not received. Sokade mail receive for xerox copy da.
फिर क्यों नहीं इधर 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 स्कैन ही करोगे था Why has this matter been listed for modification?
No, production of certified copy of the surrender sheet.
ଏମିତି କେମିତି ହେଲା? ଏଠି ଦେଖିଦିଅ
Sir.
They've been released for 3 weeks. Isn't it? So,
It has been surrendered duly, but certified copy of that order I have not received. But if I keep it to next week, I'll file the certified copy.
learned counsel for the petitioner submits that the petitioner has already surrendered and that she will produce the certified copy of the surrender certificate
By next week.
by next week. Please, this matter. Huh?
25th July.
25th July. Surrender certificate be filed in the meantime. ଏମିତି କେମିତି ହେଲା ମୁଁ? ସେଟା ଦେଖିଦିଅ ହଁ? Yes.
Item 46.
Is this your matter?
May I plead your lordship?
Just a moment. Your matter?
I have found that.
All right.
May I plead your lordship? Item 46. The lordship offences under section 21C and 29 of the NDPS Act. And the petitioner is in custody since 18/8/2021. The amount of brown sugar that has been seized from is 270 grams. And on 21/9/2023, your lordship, he had been released on interim bail and he had surrendered in due time. After for 3 months, then he surrendered. After that, he is in custody.
That is all the relief that you could have got and you have got it. Brown sugar or brown sugar is a thing both.
Since 2021, he is in custody. No trial has been initiated since then.
All these factors will pale into insignificance looking at the brown sugar thing. ଗଞ୍ଜେଇ ଫଞ୍ଜେଇ ହେଇଥିଲେ ଯେ ଗଞ୍ଜେଇ ଟିକେ ଦଉଛି ଗଞ୍ଜେଇ 500 କେଜିରେ ଗଞ୍ଜେଇ ଦିଆହଉଛି।
All other accused are also on bail.
ଯାଉ କିଛି ଦିନ ଯାଉ। Please, this matter 1 week after.
From his conscious position, it has been recovered. अन्य लोगों पाखରୁ ବାହାରିନି।
Brown sugar.
Item 47.
Yes, Mr. Pradhan.
Interim bail application.
Application for interim bail.
Lage. My lord, got it? Your petitioner is in custody since more than 2 years. 302. Earlier bail application rejected.
You have enclosed some medical documents.
Again, these are the medical certificate with respect to the wife. Suffering from chest pain and gallbladder stone.
So let him take instruction.
Yes, sir.
Yes.
Yes, yes.
Then State Council is directed to take instructions with regard to the medical documents enclosed to I 715/2024. Is this matter 25th ହେଇଯିବ?
Yes, ma'am.
25th. This is an interim application, so
Yes.
Yes.
Item 48.
May I plead your lordship? Laterite.
କଣ କହୁନାହାନ୍ତି?
Laterite theft case, my lord, petition is the owner. Owner of the vehicle.
Honor of what? The laterite?
Owner of the vehicle.
Yes.
The lordship, I am on behalf of Mr. Armasanti. The matter may be adjourned for some other day.
Which matter?
କାହା ପାଇଁ ଆପଣ?
Item number
48.
48.
48 ଆମର କାହାର? କଣ କଲେ ଆମେ? ଏଇଟା ଚାଲିଛି ତ?
କେତେ number? 48 weekly list ରେ କହୁଛନ୍ତି।
Oh, but the weekly
It has
list
not
କୁ।
been started, at least.
କଣ? କହୁନାହାନ୍ତି? ସେମ୍ ଅର୍ଡର କରିଦେବେ ଆଉ କଣ? ସେମ୍ ଅର୍ଡର।
Item 49.
My lord, renewed prayer for anticipatory bail, but I have committed a mistake, my lord, while preparing the brief. The surname of the petitioner I have wrongly typed as Maji instead of Das, DAS.
ରେକର୍ଡ ଅଛି?
Earlier filed and
2023 ର କାଇଁ ହବନି?
earlier filed and disposed of. First or secondary order has been granted. How is second application?
Second application କେମିତି maintain ହବ?
My lord, now some new
First or second
materials have come,
parity
your lordship,
and-
charge sheet has come.
Yes, parity order has
my
also
lord,
been.
ହଁ ଯେ ଏଇଟା କଣ ରେଗୁଲାର ବେଲ୍ ନେଇଛି? ରେଗୁଲାର ବେଲ୍ ରେ ଆପଣ ସବସିକ୍ୱେଣ୍ଟଲି ଫାଇଲ୍ କରିପାରିବେ। I don't have to tell you that you are so vastly experienced, Mr. Sahu. You tell me how is it maintainable?
My lord, with regard to maintainability, it's my lord's kind discretion. Because some
Modification may be done in that order, provided you file an application there. Now, what is the order there?
My lord,
And I have said to maintain, I have also said to maintain parity.
my lord, what has happened, I took instructions. He's a distressed lady and mother and son both have been charged. But this lady, I took pity of the situation only because of the fact that 2 years baby left by the deceased. This lady is maintaining that 2 years baby by moving from this place to that place. And she's actually, my lord, is a poor lady. She's an actually distressed lady. So, in view the earlier order, your lordship, I could not download. And today I saw that your lordship has passed a very reasoned order. But my difficulties are that your lordship may kindly show some compassion in view of the fact that she is taking care of a minor child.
I made
And I have given the
whether
paper.
compassion or otherwise, it can be shown only in that case, not in this case. You file a petition for modification.
In that case, I will file a
You
petition.
petition for modification, let it lie over so that you can withdraw this.
My lord, I may be permitted to withdraw this subject to correction of the title, and I will file a modification petition in that case.
No, simply withdraw it. Why are you correcting it?
Yes.
Simply withdraw it.
I am permitted to.
No, I mean the surname has been wrongly mentioned.
Surname has been wrongly mentioned as
अच्छा हो सेटा को correction करेगी permitted to এটা करिवे नहीं.
नहला असुविधा.
I am saying हाँ सेटा असुविधा. Learned counsel for the petitioner is permitted to correct the typographical error in the name of the petitioner. कोर्ट तो हो फिर नहीं.
In the office, my lord.
In the office. List this matter.
Along with the disposal of
Along with
application.
ABL appeal number 1288 of 2023. In that case, you file application for modification.
I will take recourse of law by filing an IA by ventilating all of my grievances.
All right. 25th July. How about the 25th July?
Item 50. May produce your lordship Miller. The assistant other allied offense. Other co-expense.
Pramod Rai कर दो. Pramod Rai. कौन अच्छी अन्य कौन ऑफेंस अच्छी 307 अच्छी तो 307 तो जो ऑर्डर ऑफ है कौन सा कर दो ऑल
307
Or similar you lordship co
दो ना
in this case.
दे अच्छी तो
That's right, wrongly typed as BLP. This is the ABL.
Yeah, but थिबो हम ऑर्डर टा ना सुन. Yes.
Okay.
So item number 27.
Similar, I could not reach.
27.
Directed by the court.
27. Yes.
I was directed by the court to submit the speed post along with the requisites. But that is not available at Kendra.
The requisites file be accepted and notice be issued fixing a short returnable date. Release this matter July. August.
1st August.
तापरे
8th August.
8th August.
5
Yes.
August to sir अच्छी मतलब 5
हाँ.
August को CPT posting अछि.
So ये कर दो तो देखो adjournment. You will seek adjournment, it will be considered, है ना?
Obliged.
Yes.
So item number 42.
May I please, Your Lordship? My lord, here the petitioner is in custody since 29/2021, my lord. Approximately 3 years in custody, my lord. And my lord, out of some witnesses, my lord, 3 witnesses has been examined, and out of 3 witnesses, 2 are the my lord eyewitnesses. And they are not
Sunita Das has not yet been examined.
Yes, my lord.
I'd like to.
Is only.
I want to see Sunita Das.
And hostile that Sunita Das may be examined.
My lord, several notice has gone to Sunita Das. My lord, she was not turning up since 2023, my lord.
Then I'll look at her 161.
Yes, my lord. 161.
161 ରେ କଣ ଅଛି?
Seniority.
କାହିଁକି ସୁନିତା ଦାସ କଥାଟା କାହିଁକି କହିଲେ?
Yes, ma'am.
Yes,
I know.
okay.
The court below has submitted a report stating that Sunita Das has not been examined as a witness in the trial as yet. Sri Paul, learned counsel for the petitioner, submits that as per his instructions, said witness is not turning up despite repeated summons
Yes,
by the court below. The court below is directed to take all necessary steps including coercive steps to examine said witness Sunita Das at the earliest, and to transmit the copy of the deposition for perusal of this court. List this matter on 8th August.
Okay. Next.
मुझे ऑर्डर पास कर नेक्स्ट वीक रही जो
No, 1 week after.
302 अरे वर्ड
No, all the queries has been granted there.
मुझे सुनीता दास देखे था पर करी
No, 161 ta. Yes.
अच्छे अपन को
By next date all.
in the meantime up to date case diary be obtained by the state council. Yes, हम नहीं चला देखो आओ पास हो रहा लगे दे टूटा पास हो रही थी
Quickly list item number 3.
none appears. List this matter next week.
Item number 10.
The council has expired. The office to find out if any other council has been engaged in place of the previous council. Yes. List this matter next week. होता रहता पर 29 July.
So item number 15.
So respondent has died. I have to take substitution. I have to file a substitution petition. Your lordship has granted me time on 20th for 15 days. Some of that.
2 weeks further time is allowed to the appellant to take steps for substitution. It is made clear that no further time shall be granted. But last part yes.
Item number 16.
Already in item 16, appeared suo motu on behalf of the respondent. The state has filed an appeal with a leave to appeal petition and a 4.5 years delay condonation petition. I'm only praying for next week. I'll file objection. Your lordship may hear it, madam. Where the appellate court has categorically held that the property was belonging to the party who mortgaged it to the OSFC, and on auction I have purchased the state is not required to be made a party. Despite that, the state has filed an appeal. I only pray, my lord, your lordship may kindly take up next week. I'll file the objection, madam.
Prayer for adjournment is made on behalf of the respondents. List this matter.
Yes, madam.
In the week commencing 22nd July, objection if any to the petition be filed in the meantime.
Item number 21.
Item 21.
Your lordship fixed it to 27 July.
22nd. Yes.
22nd. Right.
Item 21. None appears. So adjourn करते. In the week commencing 29th. Yes.
Item number 30.
Yeah, none appears.
Item number 33.
May I please, lordship? This second appeal arises out of a confirming judgment, your lordship. It's a matrimonial dispute.
Confirming judgment?
Confirming judgment. It's a matrimonial dispute. The petitioner, the appellant here, the plaintiff filed a suit for dissolution of the marriage, filed an application under section 11 of the Hindu Marriage Act, and in alternative section 13, it was applied for if the marriage is found to be subsisting. The suit was dismissed, and the 10,000 rupees per month when maintenance was granted. Thereafter, he approached the first appellate court. There also he failed, but the quantum of maintenance was reduced to 8,000 rupees. Lordship, your lordship kindly have a glance on the order dated 7/2/2024.
So what happened? They did not appear.
Yes, the respondent appeared,
and thereafter, on the subsequent date, this honorable court deemed it fit that a chamber hearing should be done so that the marriage can be dissolved and a amount can be fixed, my lord. Because this appellant is married and he is having call it tomorrow.
You have been informing this since, I think, day before yesterday.
That's he was supposed in the court. He was supposed to appear.
You start, you begin. You begin. କାଲି ବି ଆପଣ କରିଥିଲେ ଯେତେବେଳେ ପଡିଥିଲା.
He is ready.
With your lordship permission, may I apprise your lordship?
Yes, yes, certainly.
My learned senior has to argue. I'll.
Doesn't matter. ନା ଆଉ ଗୋଟେ ଫାଇଲ ଧରିକି ଆପଣ ଅଛି ମେନସନ କରୁଛନ୍ତି.
By mistake, your lordship, that there were two matters. Your lordship.
By mistake ନୁହେଁ, ସେଟା ବି ଗୋଟେ trick of
my
advocation.
39 is I am ready. I have read that file, so I was to take adjournment in that. So
you are ready. That is why you wanted to take adjournment or what?
the 39.
ବସନ୍ତୁ. 273 matter.
Your lordship, here the appellant, plaintiff is the appellant. Your lordship.
Let me look at the substantial question of law.
Your lordship.
Yes.
Your lordship. Plaintiff is the appellant. Your lordship. Here the plaintiff has filed the suit for declaration of right, title and interest and confirmation of possession, and in the alternative for recovery of possession and permanent injunction. Your lordship. Now, trial court dismissed the suit, your lordship, and that was also confirmed in the first appellate court. It's a confirming judgment, your lordship. Now, case of the plaintiff is that, your lordship, one Mana was the common ancestor of the parties, your lordship, who died leaving behind two sons, Devra and Dumka, your lordship. Now, Devra had two sons, Guru and Bhujo, and one daughter, Sunya. She has not been implemented as party as she has got no interest in the suit property, being daughter in Santhal community, your lordship. They belong to Santhal community, your lordship. Now, Bhujo died issueless. The plaintiff is the daughter of Guru through her mother, Salma. Defendant belongs to the branch of Dumka, your lordship. The common ancestor Mano, he had a total property of acre 14.27 decimal. Now, after the death of Mano, Devra and Dumka, who were the two sons, there was an oral partition in the year 1970 between Goro and Dula, in which her father Goro, he got half property, acre 7.14 decimal of land, your lordship, which is the lot number 3 of Schedule B property in the plaintiff, your lordship. Now, Goro died in the year 1971, and thereafter this plaintiff and her mother, they possessed the suit land, which fallen to their share. However, in 1986, Hal settlement operation was commenced, in which plaintiff also filed an objection. But erroneously, her name was not recorded, and the entire suit land, it was recorded in the name of the branch of Dumka. Therefore, this she has filed the suit, your lordship. Now, defendant case was that there was no prior partition, and plaintiff and her mother, they never possessed the suit. Plaintiff never raised any objection during the settlement, though it is not factually correct. And the settlement operation was, during the settlement operation, it was rightly recorded in the name of the father of this Dumka, your lordship. Now, finding of the trial court, your lordship, is that since the plaintiff failed to prove prior partition between Dulla and Goro is the father of the plaintiff. So therefore, she has got no right over the property. Even, your lordship, my humble submission is, your lordship, even if there was no prior partition, on the basis of notional partition, she is entitled to get the share out of her father's share, your lordship. That has not been considered by the trial court or either in the first appellate court, your lordship. This is number one. Second, your lordship, one more issue. Trial court held that suit is not maintainable as the civil court has no jurisdiction to decide the validity of the order passed by the consolidation authority. Now, this finding was set aside by the first appellate court, that there is limited area where the even civil court can exercise its power over the order passed by the consolidation authority. This finding was set aside by the trial court. However, first appellate court is that when the appeal memorandum was presented in the first appellate court, it was not accompanied by the judgment and decree of the trial court. So therefore, on that ground, first appellate court dismissed the appeal that since it is not in compliance with the order 41, rule 1 of the CPC, therefore it set aside. Now, in respect of this, your lordship, there are number of judgment by our own High Court as well as Supreme Court that it's a curable defect, and the first appellate court should have granted the liberty and opportunity to the this appellant.
Let us come to the finding.
Your lordship.
No, decree টা ଦେଇନଥିଲେ.
Your lordship, judgment and decree of the trial court was not accompanied with the
Judgment ଥିବ, decree ଟା ନଥିବ.
decree, your lordship. I'm sorry.
But there is a provision for filing that to that effect in the CPC.
Your lordship.
96.
It's order 41, rule 1, C3 अच्छे sir. That it must be accompanied with the judgment and decree of the trial court. However, it's a curable defect, your lordship. Let's start with your lordship, page number 12.
Just a moment.
Your lordship.
It's order 41.
Your lordship, order 41, rule 1. Your lordship.
Yes.
Your lordship. Now the finding is, your lordship, page number 12, para number 17. Start from para number 17. Since maintainability of the appeal has been challenged on the ground of non-compliance of the provision of order 41, rule 1, the same must be examined at the outset before considering the appeal on merit, your lordship. Then para 18 is the verbatim of order 41, rule 1, your lordship. Thereafter, in the present case, para number 19, your lordship. Judgment was delivered on 17/11/2000. Decree was passed on 24/11/2000. Memorandum of appeal was presented on 3/3/2001. Certified copy of the judgment of lower court was filed on 31/8/2001. While presenting the memorandum of appeal on 3/3/2001, the appellant has not sought for the leave of the court for dispensing with filing of the copy of the judgment. Thus, the appeal was imperfectly constituted on 3/3/2001. Admittedly, certified copy of the judgment was filed after expiry of the period of limitation prescribed for filing of the appeal. No prayer has also been made for condonation of delay in filing the certified copy of the judgment. No effort was also made for filing petition for condonation of delay, even during course of hearing of argument in the appeal, as if counsel felt that filing of a copy of the judgment is not necessary in appeal. So on these findings, your lordship, then finally, page number 14, last, there is sufficient force in the contention of the learned counsel for the defendant respondent that the memorandum of appeal is liable to be rejected, your lordship. Now, your lordship, there are number of judgment, your lordship, in which it has been clearly stated that it's a curable defect, your lordship. Though it is a requirement, but it's a curable defect, and learned court should have granted opportunity to file the certified copy of the judgment and decree.
But you did not seek leave of the court,
your lordship,
to dispense with the filing of the judgment for the time being.
There are two submission, Your Lordship, here. Number one, Your Lordship, the filing of a written application for condonation of delay is not necessary. Even on the oral argument, it can be accepted.
Where is that argument? That argument has not been reflected in the judgment.
Your Lordship, there has been argument. Second contention is that if the Honorable Court felt that the compliance was not made, then it should have dismissed the appeal at the very threshold. But once the first appellate court has admitted it and it has gone into the merit, then at the subsequent stage, it could not have dismissed the appeal on that ground, Your Lordship.
No, limitation ground can be taken up.
I may read that judgment, Your Lordship, the relevant paragraph. Para number 21, Your Lordship. If I may read, Your Lordship. It is therefore clear from the provision of Order 41 CPC that once an appeal is not dismissed under the provision of Rule 11 thereof, the appeal is to be admitted and a date of hearing is to be fixed, and notice of such date of hearing is to be served on the respondent. The only provision which authorizes the appellate court to dismiss the appeal thereafter is under Rule 17 of Order 41 CPC, which provides in sub-rule 1 thereof that where on the day fixed or any other day to which the hearing of an appeal is adjourned, the appellant does not appear when the appeal is called on for hearing, the court may make an order that the appeal is dismissed. In the explanation to this rule, it has been provided that nothing in the said sub-rule shall be construed as empowering the court to dismiss the appeal on merit. When an appeal is dismissed under sub-rule 1 of Rule 17, the provision for restoration of the appeal, commonly called as readmission of the appeal, dismissed for default, is prescribed under Rule 19. Now, in the fact of the present case, the appeal being admitted by the learned lower appellate court and summons have been issued to the respondent, the learned lower appellate court was not authorized under law to dismiss the appeal on the ground that there was no proper presentation of the appeal, as the certified copy of the decree was not filed along with the memo of appeal. So it has been clearly described, Your Lordship, that once the appeal has been admitted and summons have been issued, now after that it could not have dismissed the appeal that the certified copy of the judgment and decree was not filed. It has been settled by Hon'Ble High Court, as well as there are other judgment also, Your Lordship.
Shut up.
Your Lordship.
Come to the merits.
Your Lordship. Now, this is in respect of substantial question number 1, Your Lordship. Now, the second question, Your Lordship, the second substantial question of law, whether in the absence of any specific plea of ouster raised by the defendant before learned court below has committed an error in holding that the defendant have perfected their title by way of adverse possession over a joint family property. Now, Your Lordship knows that in respect of joint family property, adverse possession cannot be granted because possession of one co-sharer will be deemed to be the possession of other co-sharer. However, in the present case, though there was no specific plea of ouster in the written statements, even thereafter, the learned first appellate court has held that the defendant has perfected their title by way of adverse possession, which is not tenable under law, Your Lordship. Now, I may come to that finding, Your Lordship.
Yes.
Your Lordship. Page number 21, para number 36, Your Lordship.
Yes.
With regard to limitation, I find that objection case number 61686 filed at the instance of plaintiff was disposed of on 2886. The suit has been filed on 2199 after expiry of 12 years of the period of limitation. The defendant challenged the title of the plaintiff in respect of A scheduled property during the course of settlement operation. When objection case was dismissed on 2886, the plaintiff at least know from that day the defendant number 1 was denying her title in respect of Schedule A property. She was also not found in possession of any portion of the ancestral property, as the settlement authority found exclusive possession of defendant number 1. The plaintiff therefore knew at least from 2886 that defendant number 1 was displaying hostile animus. The suit therefore should have been filed within 12 years from that day, but it was filed on 2/1/99, by which time 12 years had already been lapsed, and defendant therefore had clearly perfected their title by adverse possession or ouster, as the case may be. Now, Your Worship, on the one hand, the learned appellate court is describing the property as the ancestral property, and the other hand, it has also gave the finding that the defendant has perfected their title by way of adverse possession. Now, on the basis of possession. Now, Your Lordship, in case of ancestral property, on the basis of possession, adverse possession cannot be taken because possession of one co-sharer will be deemed to be possession of all the co-sharer. Secondly, Your Lordship, factually also, now that this date 2886, this was the appeal. Thereafter, revision has been preferred. That date is, Your Lordship, (12/3/1987), when that was rejected, and this appeal was filed on on January 1999. It is still within 12 years, Your Lordship. So factually also this finding is wrong, Your Lordship.
All right, hold part. Does this matter? Who's for the other side? No one is
No one
appearing.
has appeared.
Oh, I'll just grant one more opportunity. If it doesn't appear, I'll close it.
Your Lordship.
But or in part, let this matter next week.
Obliged.
No, we commencing 15 July. আর উইক হবে না আর উইক রয়ে যাচ্ছে পাঠাটা তো ঠিক আছে হ্যাঁ নেই আর এসে আচ্ছা ঠিক আছে বলে 15 জুলাই
Item number 38.
ରେସ୍ପଣ୍ଡେଣ୍ଟ ଆଜ୍ଞା ଦେଖନ୍ତୁ ଅର୍ଡର ସିଟଟା 7-8 ଥର 9 ଥର ଆପିୟର କରିନାହାନ୍ତି ଠିକ ଅଛି ଅର୍ଡର ସେ ଆପିୟର କରିନଥିଲେ କି ଏଠି ବି ଆପିୟର କରିନି ଆଇଏଟା ଡିସମିସ୍ ହେଇକି ବି ହିୟରିଂରେ ଆଜ୍ଞା 3 ଥର ପାସ କରାଗଲାଣି ଆଇଏଟା
ଲାଷ୍ଟ ଥର ଡିସମିସ୍ ହେଇଥିଲା
ଆଇଏଟା ଡିସମିସ୍ ଆପଣ କହିଲେ ନେକ୍ସଟ ୱିକ୍ କରିଦେବା ହିୟରିଂ ପାଇଁ ଆଣିବା ଏ ବି ଆସୁନାହାନ୍ତି
None appears. For the appellant on repeated calls, learned counsel for the respondents is present. The previous occasions also, there was no appearance, for which the interlocutory application filed by the petitioner was dismissed. Since there is no appearance, it is presumed that the appellant is no longer interested to prosecute the appeal, which is therefore dismissed for non-prosecution. এটা আমরা প্রিভিয়াস ম্যাটার দেখো
Item 39.
I am therefore the respondent.
May I please alert this? It's a suit for declaration of the sale deed at Exhibit A as invalid and not binding on the plaintiffs, and the declaration of the right title interest of the plaintiffs and D5 and recovery of possession. The defendant number 1 is the present appellant. It's a confirming judgment.
Yes.
But it's the case of the plaintiff is D5 inherited the suit from his suit land from his father. In 1987 settlement, D5 has been recorded as the tenant. In 1993, they constructed a house, and plaintiff number 2, who happens to be the son of D5, was residing occasionally on the said premises. On 23rd to 1993, D1 to D4 entered the suit land, and claiming to have purchased the suit land, demolished the thatched roof, the kacha house that was constructed on the suit land. The sale deed they say that the sale deed that has been executed in their favor, like D1 to D4, for the present appellant, D1 is the present appellant before this court, has been executed fraudulently in connivance with D6. They say that there is no sale deed that has been executed, and so the suit. So they have filed the suit. D5 also enters appearance and supports the plaintiff. D5 and D5 is the father, and the plaintiffs are the sons of D5. The case of the defendant, the present appellant, is that D6 purchased the suit land from D5 in 1959 by an oral sale by paying a consideration amount of rupees 90, and the possession was handed over to D5 in 1959 itself. In the 1987 ROR, D5 name has been recorded as the note of possession is in favor of D6. Even though the suit land is recorded in the name of D5, D6 possession has been recorded as well, note of possession. In 1988, subsequent to the recording of his name, D5 sworn an affidavit stating therein that he has sold the suit land to D6. Then subsequently the sale transaction took place in 1993 in between D1 to D4 and D5, wherein D6 has signed as a witness to the sale deed. The D1 to D4 consulted their lawyer in Baripada, and he suggested that because there has been no sale deed executed to effect the oral sale in 1959, they were suggested that D6 has to be a signatory to the sale deed, and accordingly D6 had D6 wasn't signatory, and the sale deed was executed. The trial court framed certain issues out of which the pivotal issues were issue number 4, 5, and 8. 8 being the most important issue, wherein the issue that was decided was there any sale to performer defendant number 6 by performer defendant number 5, and was the performer defendant number 6 ever in possession of the suit land?
Before that, issue number 3 is important. What is the nature of the property?
Issue number 3, 5, and issue number 3.
What is the nature of the property?
Yes, whether it's ancestral property or not.
My lords, issue number 3 is the suit land a part of the ancestral property of the plaintiff and performer defendants. The court's finding is that because not all there was to answer that, the court have examined the defendants have
What was the finding, tell me? How is that issue?
Page 12 and 13.
So, he holds that there was a prior partition. The suit land is part of ancestral property of the plaintiff and
The admitted case of the defendant that it's a ancestral property.
It's an ancestral property.
Then?
The court held that
what about the sale, oral sale?
Oral sale, the courts have held that no, there cannot be any oral sale. But my lords, as per section,
Defendant number 6 himself admitted that when he was a signatory to the sale deed of the impugned sale deed, my lord, he cannot say that I purchased that property in 1959. So,
because he was a signatory, this arrangement between the D5 and D6 was subsequent to which the sale deed was executed, was because there was no sale deed executed between both D6 and D5. So only that, as per the advice of the council, it was drafted in such a manner wherein D6 was a signatory. But my lords, as the trial court has found that the sale cannot be done, and D6 have also executed a document, the Panchayat Bantana Patra at Exhibit K.
The suit was decreed and the sale deed was held to be invalid.
Yes. It was confirmed by learned first appellate court as well.
You are the plaintiff.
Yes, ma'am.
All right. Heard in part, please this matter. এই গোটে রয়েছে তোদের দুইটা হয়ে গেল সেকেন্ড আপিল দিতে আরো উইকলি কোন ক্ষেত্রে আছে বাকি না আরো উইক দুইটা আছে তো সেকেন্ড আপিল ঠিক আছে 22 জুলাই
Item number 41. My lord, that is my lord and senior Mr. Kishore Mishra, that's the brief. Then after his death, he had transferred him, but the lawyer who had given the brief, he had taken back to engage some other lawyer. You know, I wanted 2 weeks time so that I will hear.
the call on the counsel appearing for the respondent submits that the brief has been taken away from him, but he undertakes to inform the court as to who else has appeared in his place.
Yes, ma'am.
List this matter. I'll adjourn it list this matter in the week commencing 29th July.
Man, 49.
এটা পাঠানো হয়েছিল কালি পাঠানো হয়েছিল তাহলে না থাও কিন্তু
Item number 42.
42
And for the respondent, the last occasion they sought for adjournment. There was 15 adjournments and last occasion also pass over.
next week as we none appears for the appellant on repeated calls. Learned counsel for the respondent is present. List this matter next week. Yes.
For the appellant, my senior Mr. Ratho will argue this matter.
Yes.
He's on his legs now. So
Yesterday also there was no appearance. Therefore, adjournment is made on behalf of
for some other
the appellant, which is objected to by learned counsel for the respondent. List this matter next week. It is made clear that no further adjournment shall be granted. Yes.
Item number 43.
Is your matter.
Judgment fully supports me. Same issue, Millard, I have marked it. Same points. There, Millard, he agreed that they're survivors, but they cannot be a party. But here, Millard, he agreed that she is a survivor, but suit property she cannot. And second, Millard, your lordship also formulated a question whether the children begotten through remarriage of widow are entitled to succeed the property at initial. Here also, Millard, same. Millard, ground A. Ground A, whether the land lower appellate court that property inherited by Hindu family from her first husband shall revert back to the legal age of the first husband and not to the issues of the female born through the second husband. Mr. Justice Raghuveer Das Millard, he said, if natural daughter and also second, same home, then either of them are entitled. That is the judgment of.
Yes. So.
I'm for the respondent, my senior advocate, Mr. Ratho.
No, yesterday this is a part-heard matter. This is a part-heard matter. If he doesn't appear, I cannot wait. No, how can I wait? The senior counsel has argued his matter. Today also he is present. He should be there or he should be ready. He should be ready. Where is your file? What is the matter? Have you read the file?
I have power on this.
I am giving you power. The court is granting you the power. You are asking for adjournment. You have not gone through the brief. The senior counsel has been arguing since yesterday.
So last time.
Heard further arguments in part. Heard in part. In this matter, it was short point.
Next week.
Next week.
Item 44. I am for the appellant, my lord.
Who's for the respondent?
Learning senior Mr. Panda.
Ashupara or Conquer? Place this matter in the week commencing
9th July.
29 July.
Item number 45.
Sir, the urgent for the.
45, I need to have the judgments of both the courts. I don't have anything other than the
It
appeal.
is your matter.
No, it's the state is there.
No, 45 is not state. Oh, state is the other side. Yes.
45, yes.
All right.
I need to have
29
judgment.
29 July.
Okay,
Week commencing 29 July.
obliged.
Item number 48.
None appears. 29 July.
Item 5th August.
5th August.
Item number 52.
52, my lord, on behalf of Mr. Ashok Das, my lord, he has undergone operation. The lordship may call this matter 3 weeks after, my lord. I have taken consent of the other side.
All right. Therefore, adjournment is made on behalf of Sri Ashok Das, learned counsel for the appellant, who has undergone the surgery. List this matter
20th August. Sir.
on 20th August. In the week commencing 20th August.
Continue, my lord.
Interim order shall continue.
Obliged.
Item 48 on behalf of Mr. Mahanti, I have been instructed to seek an adjournment.
Item 48.
48.
This has already been adjourned.